Good morning, ladies and gentlemen. Thank you all for coming this morning. It is my pleasure to introduce to you the my co-chair of the Alternate Business Structures Working Group, Malcolm Mercer, who's a partner at McCarthy Tétrault, one of those modestly sized law firms here in Toronto. And I would also, it is my great pleasure to introduce to you the Treasurer of the Law Society of Upper Canada, Thomas G. Conway, who is going to bring opening remarks.
Well, good morning, everyone, and on behalf of the Law Society of Upper Canada, welcome to this symposium on alternative business structures. Nous sommes extrêmement heureux d'avoir un groupe très distingué d'avocats, de pairs juristes, de représentants d'organisations juridiques et de célèbres personnages avec nous aujourd'hui. I would like to extend a special thanks to those who have traveled from both near and very far to be here. We're looking forward to your participation today. And Professor Flood, I can tell you that we ordered up the rain just so that you would feel like you hadn't left London.
Thank you.
This morning I want to set the stage by talking a bit about three things. First, I'd like to discuss what we mean by the term alternative business structures and why it's vital for Ontario to consider such structures now. Second, I will provide an overview on the Law Society's effort to consider alternative business structures through its working group. And finally, I want to touch on what we hope this symposium will achieve. So let's consider for a moment the term alternative business structures and how they relate to Ontario. The word alternative suggests something outside the current regulatory framework. But as we will see over the course of the day, what may be considered alternative in one jurisdiction might very well be permitted in another. The Law Society is uniquely positioned to begin this discussion, having been the first jurisdiction in Canada to license paralegals on May 1st, 2007. And there are now approximately 5,000 active paralegal licensees in Ontario. And just as other jurisdictions are interested in Ontario's experience with paralegal regulation, so too do we in Ontario follow developments elsewhere with great interest. Legislation was enacted in Australia in 2001, which permitted lawyers in New South Wales to incorporate, share fees, and provide legal services, either alone or with other service providers who may not be lawyers. Studies there have revealed a significant decrease in the rate of complaints made by clients to the regulator without any apparent harm to clients or to the public interest generally. In England and Wales, barristers, solicitors, and certain other legal service providers can apply to practice through an ABS license, whereby they may share management and control of firms with others such as accountants and real estate agents in a new business entity. In the past 18 months, over 200 ABS licenses have been granted. Preliminary research also suggests that alternative business structures in England and Wales are more innovative and may be more effective at resolving complaints about service. Nous pouvons et nous devons déterminer s'il y a des exemples d'autres ressorts qui peuvent améliorer la prestation des services professionnels juridiques aux Ontariennes et aux Ontariens. Nous ne sommes pas seuls dans ce travail. D'autres barreaux canadiens envisagent les structures d'entreprise alternatives. We're already seeing that regulatory changes in other jurisdictions can have an impact here. For example, Canadian law firms have merged with law firms in jurisdictions that permit alternative business structures. Global law firms with an Ontario presence are exploring or are already delivering legal services through alternative means, including insourcing Canadian legal work to lower cost jurisdictions and outsourcing certain tasks. Information technology developments assist individuals to customize and complete legal documents online. Current technology also allows work to be done in much greater volume and at a lower cost than was previously the case. While we are in the enviable position of being able to consider the significance of developments abroad in our own context, we must keep in mind that the legal world is changing in ways that are already having profound impacts on Ontario lawyers and paralegals. And I think you will agree that it is preferable to lead the way forward rather than being swept up by the transformations that are taking place elsewhere. And this brings me to the second part of my remarks. What is the Law Society doing to consider alternative business structures? In late 2011, Convocation made alternative business structures and law firm financing a priority. It established the Alternative Business Structures Working Group in the spring of 2012, and this group, chaired, as you've heard, by Susan McGrath and Malcolm Mercer, has been hard at work during the past year. The working group first benefited from discussions with experts in professional regulation and global trends in legal services, and some of these experts have joined us for today's program, and we're delighted to have them here today. The working group gained invaluable insights from lawyers and paralegals during meetings this summer with the Law Society's Equity Advisory Group, sole and small practitioners, medium-sized and large firms, and various legal organizations. And what it heard was a nearly universal interest about the potential of alternative business structures. Lawyers and paralegals expressed hope that such structures might assist them in running the business side of their practices with greater ease so that they could focus on providing legal expertise to their clients. Today's symposium is the third phase of the working group's efforts to date. And we have a great opportunity today to tackle the challenging but exciting issues around alternative business structures. We hope that today's session will be an open-minded and creative review of current restrictions on business structures, and that you will help us identify what factors we should consider when thinking about how our regulatory regime might reasonably be liberalized. And I would ask you to consider the following questions. Are there potential benefits for Ontarians which may be available if alternative business structures were permitted? And what are the regulatory risks that might be expected, and how might we minimize those risks? In addition, I hope you will also consider whether or how alternative business structures might assist the Law Society in delivering its core mandate in a manner that facilitates access to justice for the people of Ontario, as we are mandated to do pursuant to the Law Society Act. As Treasurer, I have made access to justice a priority during my term, and I'm particularly interested in learning whether alternative business structures is a viable piece of the access to justice puzzle. For those of you who may not be familiar with the history of our Law Society's governing statute, the Government of Ontario gave our Law Society the authority to regulate the paralegal profession in 2007, as I've mentioned, in a statutory amendment entitled the Access to Justice Act. Since that time, we have been largely occupied with implementing paralegal regulation, which I'm very proud to report was described as an unqualified success by an independent assessor appointed by the Attorney General. The Access to Justice Act also introduced a new and, as far as we can determine, unique statutory duty to, quote, act so as to facilitate access to justice for all Ontarians. The Treasurer's Advisory Group on Access to Justice started an important conversation last year, not only, and which is continuing this year, not only with the regulated legal professions, but also with the public we serve, to help us define in structural and operational terms what that phrase in our statute means. In short, we're asking for your assistance to put meat on the bone of that broadly sketched statutory mandate with the work that you'll be doing today. And while we have not reached any final conclusions, I can say with some confidence that we do not subscribe to the view that the duty to facilitate access to justice means just facilitating access to licensed lawyers and licensed paralegals, although certainly that is part of it. It may very well obligate the Law Society to facilitate access to other forms or types of legal information and services. Nor does the duty so as to facilitate access to justice mean, in my view, that the Law Society has a duty to regulate access to justice. By this I mean there may be many opportunities and solutions for facilitating access to justice that probably do not require any regulatory oversight by the Law Society, but which may well involve other actors who are neither lawyers nor paralegals. We should be mindful not to obstruct innovation by those actors if that innovation serves to enhance the public's access to viable solutions to their legal problems. Can permitting alternative business structures help us get there? Can they help us to deliver on our mandate to facilitate access to justice? These are the questions that I will have in mind as I listen to the discussion this morning. And we also look forward to further dialogue with the professions to ensure that our members' realities are understood and considered as part of the alternative business structure dialogue. So I'm very excited about the future and what we can do collectively to influence change with respect to business structures in Ontario. And again, on behalf of the Law Society, I thank you very sincerely for participating in today's symposium. Thank you.
Thank you, Treasurer, for setting the stage for us here today. I would like to also add my thanks to all of you who have agreed to participate in this exercise today. We have very interesting and provocative speakers here, but the main focus of today's exercise is to obtain your input and feedback on alternate business structures and our current regulatory framework. Are all of our current rules necessary to protect the core values of the professions and the public interest? Or do some of them stifle innovation and impede access to justice? Are all of the alternate business structures we will study today appropriate and desirable to meet the needs of modern society, or do some of them pose unacceptable risks? These are the questions that we are asking you to consider. I would now like to introduce Zeynep Onan, our Director of Professional Regulation, who is here in the room and will be with us all day. And as you know, whatever rules we propose that should be changed, Zeynep will be charged with implementing them. And I would also like to introduce Margaret Drent, of the Policy Council, to our working group, and our taskmaster who keeps us on time and on track, and Pamela Chapman, our moderator. Pamela teaches law at the University of Ottawa and is an experienced adult educator and facilitator. It is in that capacity that she will act as moderator for today's symposium. Pamela?
Thank you very much, Susan. As Susan and the Treasurer have both said, the purpose today is really discourse. So in honor of that, I'm actually not going to stand at the podium. I'm going to begin that format by telling you just a little bit about how the day will operate, and then moving us quickly into our first panel discussion. We, this morning, are really just attempting to set the stage for the discussions that we hope you will all have. We will hear from two panels of speakers who are very much comfortable in this world of ABS, a new acronym for me, and also in the world of legal ethics and professionalism. So I'll explain as they come up who they are and why we've invited them to share their thoughts, but realize that they're here not to teach us or to tell us, but really just to frame the conversation that we were hoping you will all have today. So in aid of that, they're going to stay with us today, and after lunch, we will move into a format where we all get to talk with each other. So we are hoping very much you'll stay with us. Once you've heard from others, we want to start to hear your voices. You will find in your packages some scenarios that have been crafted by Margaret and her staff to format that discussion, and each table will have an opportunity to talk about a particular scenario amongst with each other. and guided to some extent by a facilitator. You'll see that we sort of forced you to sit in groupings that might not have been obvious, but that's on purpose. We've made sure that the speakers are sprinkled amongst you so that they'll be able to interact with you and talk about their experiences both here and in other jurisdictions, and also guide you perhaps in any questions that you have and the discussions you may find yourself drawn to as you explore those scenarios. So after lunch, I'll explain a little bit more how the timing and the format of that session will work, but I do hope that you'll stick with us and start to participate more actively as the day goes on. So to say that the first panel represents who's who of the world of legal ethics and professionalism is a bit of an understatement. We are really lucky to be joined by some of the world's leading scholars on these issues, and they're going to provide you with something of an environmental scan. They're going to tell us what's happening with ABS around the world, and that is a great way to begin to frame our discussion. We are joined by Laurel Terry at my far right, who is a professor of law and the Feldman Distinguished Faculty Scholar at the Penn State Dickinson School of Law. It's a handful. She really is one of the leading scholars on legal ethics, and she's an active proponent of new frameworks for the regulation of lawyers, including the research she's done around the structural reforms in Australia and the UK that Treasurer Conway has already mentioned, and ongoing work with many of the organizations who are really devoted to improving and changing lawyer regulation around the world. Sitting beside Professor Terry is Professor Paul Payton, who teaches and is the director of the Ethics Across the Professions Initiative at the University of the Pacific McGeorge School of Law. However, he began his career here in Canada, and you'll see from his bio that he played a range of roles in both private and public law here. As with his colleagues on the panel, he too is a leading scholar and a teacher of legal ethics and professionalism, and a frequent contributor to the debates about the future of the profession that we're touching on today. He's also been involved with the debates over innovation in the US, so he'll be able to bring that perspective to his presentation. And last but not least, and first up, is Professor John Flood, who's sitting beside me. He is a professor of law at the University of Westminster in London, England, but currently, I understand, is teaching in Miami, which seems a lovely place to spend the winter, at the University of Miami School of Law. And I was interested to hear that he's teaching a course there called Global Legal Entrepreneurship, something I wish I could take. His research focuses as well on the legal profession, but also on the globalization of law. So he's been very active in research and discussions around the implications of alternative business structures worldwide, and also in particular in England and Wales. And he's going to share some of that with us today, starting now.
Right. Thank you. I've even got some pictures for you, but not as nice as the ones that the Law Society has provided. Okay. Thank you very much for inviting me, and it's interesting to be talking with you about this. So let me start in a fairly simple, benign way, if you like. Why does it matter who delivers legal services? Why does it matter if it's just lawyers? Why not let anyone deliver legal services? And when you ask that, certainly if you ask that in the US, you're put up against a wall and shot summarily. If you ask it in the UK, a few eyebrows will be raised. But just before I go on to my first slide, well, I can move over there now. Let me just put this in context, because people often don't look at this very clearly. In the UK, and I'm just going to use the UK as my example for the moment, there are roughly 400,000 people working in the legal services market. That's according to our statistics office. Of that 400,000, only 170,000 are lawyers of one sort or another. So already we have a majority of non-lawyers providing legal services in the UK. We also, as you may be aware, do not have the draconian unauthorized practice of law rules that the US has as well. That's another word for monopoly, and self-preservation. Only it's aligned with public interest and nobody can see the difference. But we know what it is. It's a shell game of a sort. Now, in the UK, we have reserved activities. We're very gentlemanly about this. And we have these rather bizarre 6 reserved activities, which basically relate to things like swearing oaths and property sales and such like and so on. But if you look at the typical workload of a large City of London law firm, or even a medium-sized law firm in the UK, 80% of what it does is not covered by these reserve activities, which means theoretically anyone could do that kind of thing. So, legal markets are not static. They're not set in stone in any way. They change. How and what causes these changes? This is where I come now to my slides. And I put up 4 potential, what I call drivers of change: socio-political, globalization, technology, and regulation. That more or less, I think, covers most of it, except as to whether you prefer tea or coffee. But no, leaving aside that, let's move on then to socio-political. I think one of the key things which has happened is, since basically the Second World War, the end of the Second World War, we've had the rise of the welfare state. And the rise of the welfare state has generated a consciousness amongst people that they have rights, that they can articulate these rights, they can demand these rights, and put forward for these rights. And I've just put down a little list of potential rights that people are concerned about. And I think in respect of legal services, one of the key ones has been the rise of consumerism. Because the notion of a profession often is, I am an expert and I will tell you what you need and how you should receive whatever it is you need. And consumerism is exactly the opposite of that. It is driving the voice of the purchaser of the goods and services to say, no, I want to have a voice in this as well. And this has been a very strong driver in change, because it means people no longer accept the status quo, no longer accept monopoly positions in this way. So this, I think, has been one of the key things. It also means it's been the rise of the complaints culture, if you like. People will now complain. And one of the barriers that the law and the legal profession came to was the fact that it's not very good at dealing with complaints from clients and consumers. And the rise of complaints over the last 20 to 30 years in the UK has been definitely one of the key features as to why legal services had to change. Globalization. Globalization is pushing things tremendously. We're going to hear more about this from Laurel Terry. We're seeing how the major law firms are coming to dominate the world, New York and London. These are the 2 main legal systems. I'm sorry to say this in Canada, but these are the 2 main legal systems, if you like, in terms of much of the global work that law firms and international businesses engaged in, hence the hegemony of the law firms of these 2 countries. New York is scared stiff at what is happening in England, because it means that the English firms may end up with advantages, but I'll talk about that. So the power of English law and New York law cannot be underestimated here. But also tied into this is, I put a little thing here, the 3.5-minute contract. There's a lovely book just come out by Milatu Gulati from University of North Carolina on how most complex contracts take 3.5 minutes to produce. That's how long it takes for the computer to spit it out. The problem is, when they do that, even though there may be adverse decisions in other parts of the world, they're not incorporated into those contracts, so the contracts are constantly being spat out, are often wrong. So we again are seeing all sorts of strange things beginning to occur here. So, globalization. Technology. We have James Peters from LegalZoom, who's going to be talking later about what's going on here. But this has been perhaps one of the biggest game changers. We see this all around. I mean, look at it now. If you go to the doctor, what do? You don't go along to the doctor and say, I'm ill, tell me what's wrong, and prescribe it for me. No. You go on the internet, you go on to WebMD and all the rest of them and so on, you diagnose yourself, you go along to the doctor and you say to the doctor, this is what's wrong with me. And what's more, this is the prescription I want you to give me for it. All right, it's not quite as simplistic as that, but we're getting there. Law is now undergoing a similar transformation, I would argue, with the result of online. We already know that eBay is one of the largest dispute resolvers now in the world, of any institution that is engaged in disputes. The European Union is pushing towards online cross-border dispute resolution. That will come very soon. We're already seeing what's happening with legal process outsourcing. We know that the computer algorithms can do discovery far better than a room full of highly paid associates these days. So this is now moving things more towards a kind of do-it-yourself law that we've seen before. Regulation. Regulation is key. People tend to think this is a simple matter, conflict between self-regulation and external regulation. Get with it, people. External regulation has been around for years and years and years. We know in the United States that there are somewhere approximately, 100 regulators of legal profession in some way or another, if you include courts, bar associations, government agencies, and Lord knows what else. It's one of the most over-regulated professions in the world. The Legal Services Act, interestingly, was meant to simplify our regulation. In fact, I think it's probably made it more complex than it need be. We now have a two-tier regulatory system, which is we have what are called the frontline regulators, Solicitors Regulation Authority, the Bar Standards Board, et cetera, who deal with their constituencies, whether it's barristers or solicitors. Above them sits a oversight board called the Legal Services Board, who basically make sure that they're playing fair with each other and being reasonably equal about this. This has only been in place for 6 years, 5.5 years. And the government, bless it, has just announced a brand new review of regulation. I was asked to speak here in March, and so by the time I've got here, the whole thing that I was prepared to say and wanted to say and so on is now up in the air again. I don't know what the situation is going to be like in the UK. We may scrap everything, we certainly won't go back, but what we will end up with, I don't know. I mean, clearly, one of the strong elements, I think, has been, and again, this is something else that Laura will be talking about, has been the influence of international organizations on the way regulatory structures are being shaped in the world. Whether that's through the WTO, through bilateral treaties, or the role of the IMF in the Troika in dealing with debtor countries in the Eurozone. Ireland is about to change its regulatory system from the Law Society and the bar to a single government-appointed regulatory agency, which has basically been demanded by the IMF, the EU, and the European Central Bank. And potentially, we could see more of this kind of move coming through. So there are increasing numbers of pressures here. And then we've got the emergence of alternative business structures, the most ungainly, unuser-friendly phrase that I've ever encountered in my life. MDPs are a variant of this. But what this regulation has tried to do, and I think this is absolutely vital, is if you look at the Legal Services Act, in the first section are a set of regulatory objectives, 8 of them, including like promoting the public interest, promoting access to justice, but also promoting the rights of the consumer, promoting the interests of the consumer, promoting competition among legal service providers. So we have a a move towards putting the consumer at the center of this entire enterprise. This is, again, another kind of game changer, I think, in the way lawyers think about the services they deliver. We also have the legal ombudsman, whose job it is to hear complaints and resolve them. Within the first 6 months of their opening, they received in the nature of 40,000 phone calls registering some kind of discontent or not. Not all of those turned into complaints, but it shows that the voice of the consumer can be a lively one at times. All right, ABS. Let's get to the gritty of it. When I showed this slide, Mr. Mercer expressed horror that he thought it meant, all these firms are closed because ABS had come on the scene. That's clearly not what's happened. But general economic conditions, loss of legal aid, the rise of self-represented litigants, and all these sorts of things are introducing threats to small law firms. It has been estimated that once alternative business structures get going, up to 3,000 law firms could disappear. Out of a number of 10,000 law firms that we have, that's quite a significant number. By the way, the Solicitors Regulation Authority says there are at least another 500 firms at risk of being closed or winding down in the next year. So there are severe pressures. Right, let me introduce you to an ABS. Eddie Stobart is one of our main trucking companies. It also sells legal services. It's been very successful. It's really a sort of brokering system. It doesn't actually ferry lawyers up and down the highways, but it puts people into contact with them, and it's been a very successful enterprise, much to the horror of many lawyers. Key examples here. Co-op legal services. At one time it used to be called Tesco Law, but now the only supermarket so far that's gone into this has been Co-op, which actually is, just to give you an idea of the way the Co-op sees how the market's going. In 2007, Co-op had 3 lawyers. In 2011, the Co-op had 300 lawyers on its staff. Last year, it announced it was going to hire 3,000 legal professionals, because that's the way it sees the legal market developing. We've got Slater & Gordon, which was the first law firm in the world to have an IPO on the Australian Stock Exchange, has now come over to the UK, bought a personal injury firm, one of the largest ones, that also has a claims management firm that does settlement work, has now bought at least another 3 to 4 law firms in this area, and is consolidating its grip on the personal injury market in a very dramatic way. It is an ABS, and it will probably go on the stock market at some point. We've got firms like Paribus. Now, this is a strange one, because Paribus is basically, it's not a law firm, but it's a collection of firms: insurance, healthcare, automotive repair, claims management, insurance work for plaintiffs, insurance work for defendants. It has integrated vertically and horizontally practically everything you can imagine in the personal injury sphere. Again, another very successful enterprise. We've got Riverview, which is a law firm that offers fixed fee work. Again, has been tremendously successful. You might think, well, fixed fees, what's so unusual about that? Is because, lawyers don't do things on fixed fees, usually. They tell you what it's going to cost at the end. I mean, look, imagine going into the Apple store and saying, I want to buy an iPad. How much is it? And they say, sorry, we can't tell you. What do you mean you can't tell you? When you get to the checkout, we'll tell you what the price is. It could be $200, it might be $400, or it might be $600. But we're not going to tell you what it is before. How many iPads would Apple sell? 0. But this is what we've got with lawyers. So this Riverview then becomes a revolutionary way of doing it. Plus, they've put all their documents on a library for free download. Go back to what I said about the 3.5-minute contract a bit earlier, and you can see that it should be free. This is all sunk cost. The research and development has been done. There's no legal expertise apart from a little tinkering going into this. The final one, BT Claims, is one of the most interesting. This is the claims management department of BT, our main telephone company that has lots of vans, has lots of accidents. They're going to take the in-house legal department out of the company, set it up as a separate ABS to handle claims for other businesses that have van fleets and so on. So we're already seeing interesting moves. One of our local governments, the Kent County Council, has now a series of public partnerships to do legal work across various areas in its expertise. Risks. At the moment, we've got what I call regulatory arbitrage. We've got 8 regulators. Anybody can apply to be a regulator. The accounting firms have done that. The Archbishop of Canterbury is a regulator. The SRA is a regulator. He regulates the notaries. And also in Queensland, Australia, for some bizarre reason. But we've got this weird regulatory system, and it means potential race to the bottom or race to the top or race nowhere in some cases. We haven't sorted out yet, and this is something that you're going to have to deal with, what the distinction really between regulation and ethics is, and how ethics is brought back into this, because often regulation excludes ethics, I think, and we need to make sure that that is taken care of. Financial risks are constantly there and so on. And one example of that is the co-op, one of the great success stories in the ABS. The co-op bank is just about to go bust, by the way. It's part of the co-op conglomerate, and everybody's working out, well, you know, if the bank goes bust, what's going to happen with the law firm? So this is not all easy going. However, we haven't seen the end of it yet. Let's have a look at what might happen. The non-existent ABS. A legal process, Pangea 3 buys a law firm. Why not? Technically possible under our ABS structure. Thomson Reuters, the largest publisher in the world, becomes a legal services provider. If you look at its makeup at the moment, it looks pretty much like that already. The Big Four all become MDPs of some kind, the Big Four accounting companies. Or, let's just sum it all up, Google buys everything, and, and there we've got the biggest law firm in the world. So I end up with basically a bunch of questions, which I think you've got to start thinking about, and everyone still has to think about, what do all these things mean now? Because you cannot take them for granted anymore. And with that, I leave you to think about it for the rest of the day. Thank you.
While she's pulling up the slides, let me say, first of all, how pleased I am to be here and to participate, and how much I'm looking forward to today. I'm going to try and cover a lot of territory. Hopefully I won't start talking too fast. I need to start my timer. Excuse me for a minute. I just want to mention that I've written a law review article dealing with the last third of what I'm talking about today, which focuses on global and Canadian trends. So if you want citations and more backup, that's available. So I'm going to build on what John talked about by telling you a little bit more about changes in the legal services market. I'll talk a little bit about globalization, and then I'll tell you about some of these trends that I see. If you don't know Richard Susskind's work, I think it's worth becoming familiar with it, because this chart in particular, as well as the book, is something that I am seeing reproduced over and over again. And what he has talked about is the movement in the legal services world, which is really what's gone in a lot of other areas, from bespoke legal services, that is custom-made, individualized, very expensive legal services, through standardization and then on ultimately towards commoditization. And the more you go along this line, the cheaper things become. And so there are pressures from clients and others to have legal services become, at least for certain kinds of matters, less bespoken and more on this other line. Another thing that I recently discovered that I find is very useful in my thinking about this is I had started to see a lot of words like creative destruction, creative disruption, positive innovation, things like that. It's showing up in the popular media a lot. And it turns out that a lot of this comes from a business professor named Clayton Christensen. And there was an article fairly recently by Professor Ray Campbell talking about how this business theory would apply to the legal services market. And if you want the two-page version of it rather than the full article, I did a Jotwell blog on it. And what Professor Ray Campbell laid out the theory, which is you have both sustaining and disruptive technologies. Sustaining technologies make an industry, product, service better. Disruptive technologies completely change the framework and the ground rules. And you tend to have disruptive technology come in two situations. Either there is a market that is not being served at all, or there is a market in which the consumers are being oversold. That is, they're buying more that they want at a higher price than what they want. And the examples he gave are when personal computers first came out, they were pretty primitive, but they were a heck of a lot cheaper than a mainframe computer. And so there were a lot of people, that was a market that had not been served, that it filled. When MCI first started competing with AT&T as a telephone provider, its services were pretty primitive. They dropped calls, they were crackly, but they were cheaper. And there are a lot of people who said, good enough. I'd rather have the cheaper MCI service than the better AT&T service. Clayton Christensen's theory also said you don't tend to have the established firms being the ones who provide this disruptive technology because they want to produce a better product, not an inferior product. And the third thing is that when you get these disruptive innovators coming in at the bottom of the market, what tends to happen is they migrate up. And just as an example of that in the legal services market, a number of years ago, back now in 2008, I went to a program at Berkeley on outsourcing legal services that was very interesting. You had users there, some of the big high-tech companies, you had providers there, and the representatives from some of the high-tech in-house counsel were saying, you know, we started out sending things to India at very low-level assignments and patent cases. And, you know, they've done more and more, gone up the value chain in terms of what they're doing as they got better and learned what we wanted and things like that. The other part of what Professor Campbell's argument talks about is how some other parts of the business school scholarship has made it fits in with this, which is that businesses tend to be one of three types. A value chain business, you take an input and you turn it into something else, like a factory is a classic example. You take steel, turn it into a car. You have solution shop, which tend to be knowledge-based. You take expertise and solve problems. That's what lawyers classically do. And then you have value networks, where the value comes by putting people together, insurance companies, eBay, et cetera. Businesses tend to be in one of these three configurations and tend not to move out of it. What Campbell said is, in a world where incumbents cannot implement disruptive change, by definition because of the theory, regulation that excludes entrants from different value configurations not only excludes just the potential entrants, but the possibility of disruptive change himself. And he then argued that that situation was true in the US because lawyer regulation limits lawyers to a solution shop configuration. I'm not sure I agree with him 100% on that. I think it might be possible to get outside that, but I think it's certainly worth considering. And I think as you consider the questions that you're going to be talking about later today, it's worth considering whether that would also be true in Canada. So what are some of the potential drivers of disruptive change? We've already heard about some of them in the introductory remarks. But I had gone back to the Law Society's annual report for 2012 and pulled out some of these things. I have to tell you, my jaw dropped when I read that first one, that the number of unrepresented litigants in some courtrooms has reached 80%. As is true in a number of jurisdictions, including my own, individuals are now going online to find the legal advice themselves on family law, estate matters, other things. And the Ontario Civil Legal Needs Project that you probably all know about indicated that there were access to justice problems. And it's not just Ontario. Your Chief Justice has talked about the epidemic of self-representation. You've got regulators elsewhere in Canada worried about demographic issues of aging lawyers, worried about rural populations being served. You've got the Canadian Bar Association with its initiatives. And you have a lot of academics in Canada who are talking about lawyer regulation, talking about these global changes, talking about access to justice. So I think that some of these potential disruptors are out there. Now, one thing that it seems to me important for you to know is that the ABS conversation, and hopefully I won't use too many acronyms that you don't know, but ABS I figure is now fair game. The ABS conversation is global. There are a lot of things happening in a lot of jurisdictions, and everybody's talking to each other and trying to figure out what's going on. And I don't think that you can solve or talk about this problem in isolation. Maybe there are a few countries in the world where that's true still. I'm not sure I believe that, but it's definitely not true here. Canada's part of a global economy. It's part of a global conversation. And in fact, North America accounts for the biggest legal services trade, according to a 2010 WTO report, World Trade Organization, which is where this came from, because we not only trade elsewhere, we trade amongst each other. This shows you the trajectory of legal services exports and imports in Canada, and there's a lot of money, $720 million for your exports, $710 million approximately for your imports. So lots of flow back and forth of people and ideas. So these developments happening elsewhere in the world, people are going to be talking about it. Now, at the conferences I go to, one of the issues that people often are talking about is the shift in the economy towards the BRICS countries, Brazil, Russia, India, China, and South Africa. And Canada, I think, is actually positioned pretty well to take advantage of some of these shifts in the global economy. As you will see by looking at the chart with the big black, this is from a Stats Canada study on the diversity in the population in Canada in the year 2031, and an increasingly large percentage of your very diverse population is going to be coming from BRICS countries. And what that means is that this is not just a Toronto global law firm phenomenon. This is going to affect Canadians all across the country. Individuals are going to have family law issues, they're going to have estate matters, and you're going to have a lot of entrepreneurs, small businesses, right, who sell to or have suppliers in the countries in which they have contacts. And so all of this, I think, is something the globalization is going to affect all of us. We're not just a little, island with a strong border around the map. Now, this has consequences for regulation, I think. And you're just talking about ABS, but I think it's useful to know that there's an awful lot going on globally with lawyer regulation, and it's all interrelated. You can talk about it issue by issue, but lately I've found it helpful to try and remember them all by saying there are issues going on of who, what, when, where, why, and how. Everywhere you turn, there's issues. So who regulates? You heard about from John all of these governmental initiatives around the world in which regulation is being taken away from the legal profession. And you certainly have nibbling of that happening in Canada. You have your Competition Bureau that's interested. You have your money laundering case with the Attorney General. You have provincial legislatures that don't trust the legal profession enough to write the good practices standards for admissions. You have, John said I would talk about it, actually I'm only mentioning it, but you have the World Trade Organization that affects lawyer regulation. You have something called the Financial Action Task Force, an intergovernmental entity, which is why you have the money laundering fights. You have the OECD making policies. You have APEC, Asia Pacific Economic Cooperation, really interested in legal services, very active. Then you have the whole issue that's been alluded to of what is regulated. It used to be that legal services and legal providers, there was an overlap. At least that's what I think the good old days look like. If it was legal services, that means lawyers provided it. And as we heard from John, that's definitely not true anymore. So regulators have to ask, what are we regulating? Are we regulating LegalZoom in Canada as service, or are we regulating providers? And if it's providers, is it just lawyers? Is it lawyers plus paralegals? Is it other people? These questions are being asked all around the world, and they're being asked, or going to be asked here as well. When are lawyers regulated? You heard a little bit in the introductory remarks about this Australian initiative, where they make people who want to take advantage of this incorporated legal practice, which has tax advantages, to have appropriate management systems. It's basically law practice management, and they've developed an infrastructure to implement that. Complaints have gone down by 2/3. It's really dramatic. And regulators around the world, including in Canada, have taken notice of this. And so there's a lot of discussion about, should we just sit here and wait for the 40,000 clients to call in and complain, or should we be out there trying to prevent it? Where are lawyers regulated? We all operate virtually now, but we are regulated on a geographic basis. It's a real mismatch that we've not yet figured out. And so if you have ABS in the UK and Australia, and they're partners with Canadian lawyers, or they're helping Canadian clients, what the heck do you do? These are all issues we're going to have to think about. How lawyers are regulated. John didn't mention this, but part of the UK reforms, they went to an outcome-focused regulation. It's supposed to be principles-based rather than rules-based. I don't really get it yet, because I don't know how you actually discipline someone. I mean, it's good in theory. I'm not sure on the enforcement and how it works, but everybody's really interested in what they're doing and how it's going to work. Lots of chat about that. And you have a tradition in Canada in some other fields of outcomes or principles-based regulation, and people are talking about it, some of your academics. Why are lawyers regulated? I think the very best part of the UK Legal Services Act was Section 1, which set out the regulatory objectives. Their list is not exactly what my list is. You have had in Canada a tradition in your purpose section of your Legal Profession Acts of talking about this, but my sense is you haven't really had the same level of rigorous debates that the UK did when they started from scratch. And I think ABS gives you an opportunity to have that. So what does this all mean? I don't think there's a magic bullet answer here. I'm a very slow decision maker. I much more like saying, this is interesting, go talk amongst yourselves, than saying, here's where I come out. And I'm still on the fence about this. I think there's incredible access to justice potential here. But I do think that the rule of law is an incredibly valuable thing here that we don't want to take for granted, and we have to think about what the risks are and whether or not we can put sufficient protections in place so that we don't lose that. I was at a conference a couple of years ago at Michigan State, actually I think both of you were there, when one of the commentators said, not Google, but the insurance companies are going to come in and take over the world, and there's going to be no choices. So I will post these slides on my webpage. There's lots to read more about it with sites, but thank you very much.
Thank you very much for the invitation to join you this morning. It's a real privilege to be here at the Law Society and to actually continue part of what's been actually a career journey for me, dating back to the time that I was in the Premier's office and working on reforms to the Law Society Act around changes to legal aid funding and the like. And so the journey around regulation of lawyers in Ontario for me is a personal one, and I'm really privileged to be back here to be part of this discussion. In terms of the dialogue for this morning, what I've been asked to do is reflect on the work of the American Bar Association's Ethics 2020 Commission, and in particular the focus is the work that I did for what became, and again, the world of acronyms, the alternative legal practice structures, and I'll talk about the ways in which acronyms and nomenclature became important. But before, I'm always one to spoil the story. So now that I'm freed from the shackles of silence as a reporter for the Commission, I'm actually allowed to have views again. And I was highly critical of the ABA process and what I considered an absurd focus on core values rhetoric as a proxy for fundamentally anti-competitive behavior on behalf of part of the organized bar. And as someone who was involved in the MDP debate since the late 1990s, and it's a privilege to see Michael again, having commissioned a report from Michael Trebelko and his colleague Lila Chorgo at that point that I know made it into dialogue in Canada, the United States, and elsewhere on consumer demand. It's a real privilege to be here again. I had said at a conference in Fordham in 2008, and in an article published in the Fordham Law Review, that the process that Ethics 2020 was to embark upon was doomed if it went the route of the MDP debate a decade prior, drowning in a sea of overblown romanticism about professional integrity being threatened by non-lawyers. I came of age at a time when the economics of the profession in Ontario in the early 1990s meant that 3 of 12, 2 of 18, 4 of 16, 0 of 10 articling students were getting hired back at the major law firms. These were the top graduates from the top schools. The economy and the economic pressures at that point meant a fundamental paradigm shift for a generation of lawyers that others did not experience, and that I think, again, as you're seeing economic pressures, particularly in the United States, bear out, bears watching. I told you so is unsatisfying, but accurate in terms of what happened with ABA's Ethics 2020. ABS was near dead from the start, and was killed fundamentally, and I'll go through the chronology, when the two co-chairs, together with a former ABA president and a very highly respected judge on the commission, voted openly in a straw poll against any move, even before the commission's working group had completed its deliberations. That largely untold story is what I'm working on for a piece that will be published in the Fordham Law Review next year. In speeches to various state bars and other groups last year, and most recently with Laurel at an ABA annual meeting in August in San Francisco, where we were on a panel with Nicholas Fluck from the Law Society of England and Wales, and also the president of the Law Society of Australia, my view in terms of what would happen or what would be necessary for change in the United States was that pressure would be coming from two ends of the supply side spectrum: large multinational or US firms with a presence in the UK, and on the opposite end, from small practitioners threatened by the rise of LegalZoom and other non-lawyer providers. And as there was more evidence of what was taking place in what I call the living laboratory of the UK, there will be increasing self-serving economically pressure from within the profession on the ABA to revisit alternative business structures. Core values be damned when financial viability or opportunity is at stake. And if the ABA doesn't respond, these forces will take the debate elsewhere and have already. In that respect, and again to summarize, I think the potentially more important threat is in state legislatures like North Carolina, where market-friendly Republicans have already floated legislation to mandate a change. Although it was taken away, it will be coming back. The Jacoby and Myers lawsuit is background noise for lobbying pressure. I wouldn't put too much emphasis on what you see as a constitutional or quasi-constitutional challenge that's being floated in the United States. But I think potentially efforts in legislatures, just as in Australia and in the UK, are the most powerful force for change, much like the signals of the OFT in the UK prior to Clementi. Finally, and in terms of a summary of what I will say about the ABA debate, the release of the ABA's formal opinion this August regarding fee sharing, which I've included in the material sent and we can certainly make available afterwards, which was punting one of the Commission's most controversial remaining ABS-related issues represents a stunning rejection on the lack of action by the Commission itself. Essentially, what you have from the ABA Standing Committee on Professionalism is a formal opinion that says basically fee sharing with UK firms is okay. That will represent a fundamental change and threat to domestic regulation in the United States. Okay, so I've said the entire piece in terms of the conclusion. Let me walk you through the story. So the ABA's Ethics 2020 Commission, for those of you who aren't necessarily as familiar with development south of the border, was created back in 2009. The ABA comes up with a commission about every 10 years, plus minus, to take a look at ethics rules. And you know, there are lots of debates, lots of process. It's an interesting dialogue. But this time in particular, Carolyn Lamb mandated a thorough review with two key elements in mind: globalization and technology. How have the rules kept up? What needs to be focused on moving forward, and what's going on in terms of the global legal marketplace. And so while my comments will focus on the lack of action on ABS, there is much, and it's all still posted very helpfully on the ABA's website, that the ABA Commission did and that rule changes came about, particularly with respect to technology, that represent really important changes. One of the things that was interesting in terms of the mandate from then President Lamb was that the Commission was directed to consider how regulatory structures can enable U.S. legal providers to compete with those in other countries. I thought that was an interesting way of positioning it. Not necessarily about core values, but how can we compete while continuing to protect the public and the core values of the profession. And in many respects, those are the sorts of questions that are being posed at the tables this afternoon as you consider these issues for Ontario. Those are the commissioners. Biographies very high-powered, representing the best in government, private practice, the academy, regulatory bodies, and the judiciary from across the United States, from across a range of very distinguished careers and practices. Also really nice people. These were the working groups that were established, and essentially to divide up the work, what the Commission did was set up working groups, populate it with commissioners and other experts who were brought in outside, and depending on the nature of the work that was being done, assigned a reporter or reporters to support that work. The reporters, the expert research resource, would be basically responsible for holding the pen, drafting a lot of the issues. Andy Perlman from Suffolk in Boston was the chief reporter, and a particular focus on technology. Brad Wendell and Anthony Sabok, for example, were reporters on alternative litigation financing, and that report itself stands as just terrific work. But note the language. So originally, this was the working group that I was assigned to and recruited to support was called Alternative Business Structures and Entity Regulation. In the end, it was called the Working Group on Alternative Legal Practice Structures. And that itself was an interesting change that reflected the politics of what was going on within the ABA during the period. Because entity regulation went away almost immediately. Notwithstanding the importance of the developments that Laurel and John have pointed to in Australia and the outcomes of the ways in which that proactive regulation have moved forward, there was no stomach for any dialogue about entity regulation happening in the United States. Ted Schneier, who was one of the commissioners, professor emeritus now at Arizona, had authored an article a decade plus prior on the importance of entity regulation and completely silenced. And the notion of alternative business structures offended many sensibilities. The idea of law as a business was anathema to many. And so the language came to this rather awkward acronym, which I've only seen it developed in the United States, Alternative Legal Practice Structures, so ALPS, a mountain perhaps too high. So this was the preliminary issues outline. And basically looking at the marketplace, looking at the ways in which core principles, not core values, and I'll come back to the core values language, of client and public protection be satisfied while permitting U.S. lawyers and law firms to participate on a level playing field. And so this notion again that somehow trade and services needed to be on a level playing field was important in terms of the way that the initial discussion was framed. I've quoted only part of ABA Model Rule 5.4, but this is essentially the essence of what they were looking at. 5.4 sub B, a lawyer shall not form a partnership with a non-lawyer if any of the activities of the partnership consist of the practice of law. This is in play. The ABA model rules serve as model rules for states or state courts, depending on the jurisdiction, essentially to adopt. There's one jurisdiction in the United States that does not have this rule in place. That's the District of Columbia, that 20 years ago changed their rules to permit forms of multidisciplinary practice. And one of the things that was important for the work of the Commission was actually the chap, Gene Shipp from DC, was a resource to the Commission and was asked, how many complaints have you had about alternative business structures, entities in the District of Columbia in 20 years? And we'll get to, how many prosecutions and the like. There were precisely none. And so this is the rest of the model rule, and we'll make the slides available later on, talking about the ways in which restrictions happen. So a lawyer can practice in a law firm that looks like a traditional bricks and mortar law firm. The ABA is also grappling with virtual practices, but that's another discussion entirely. The working group met and issued a working group issues paper in April 2011 that basically was an environmental scan of the legal practice environments with a particular focus on England and Australia, but really on England because that was of primary concern. And while it was inelegant, there were 5 essential options for action that were distilled. Moving up from the bottom, the Australia model, the Slater and Gordon, let's have law firms traded on the public markets. A variant on that, passive outside non-lawyer investment in law firms, kind of scaling it back if you think of it as an inverted triangle. MDPs that offer non-legal services, limited lawyer, non-lawyer partnerships with no cap on non-lawyer ownership, which is the District of Columbia approach, and then the most narrow possibility as an option for consideration was limited non-lawyer partnerships with a cap on ownership and other important restrictions. So that was April 2011. Now keep the dates in mind. In February 2011, the Commission said no to options D and E. So even before the working group issues paper came out in April 2011, those last 2 options were off the table entirely. And the language that you've got, and in terms of framing your own debate and discussion, you're looking for rationale, explanation as to why these options were eliminated. This is what you'll find. The Commission's determined that the following 2 options are not appropriate to be recommended for the United States at this time. Both are in place in the global legal services marketplace in which U.S. lawyers and firms engage. However, they may warrant additional monitoring and study. That's it. In terms of explanation, that was all. In June 2011, the Commission said no to option C, took MDPs off the table, and for reasons that I'll come back to as part of a postscript, multidisciplinary practice, or MDP, are 3 of the worst letters in the ABA vocabulary dating from the mid-1990s. So again, you've had the issues paper in April 2011. Before you even got to it, you had 2 of the options taken off the table. You had a 3rd option taken off the table. We met in a horrible conference room at the Delta Hotel here, the Delta Chelsea here in August 2011. And the Commission's straw poll on ABS went forward because they were trying to determine what to direct the working group. The working group had continued consultations with a number of different groups, in particular focusing on what were called the Soles and Smalls, the ABA's section that was dedicated to small practitioners, firms fewer than 10, as well as the Young Lawyers Division. And one of the things that was most interesting in terms of those initial discussions with both groups is that there was incredible interest in the possibility of exploring some variant on the traditional practice model. So for Soles and Smalls, they saw the competitive threat from an entity like LegalZoom. And just as an anecdote and an aside, I was at the ABA's conference on professional responsibility in Seattle a few years ago, and Chaz Ramphithal from LegalZoom was in attendance. Nobody would talk to him. Being the sort of friendly guy I was, I went over, had a drink, started talking. I thought, you better know what these guys are doing. And you'd better, in particular, know what they're doing when you look at the way in which they're trying to raise money in the capital markets to fund their business model. Their filings with the SEC give you a story that, as one of the people at the Wisconsin State Bar told me, thanks for scaring the living daylights out of us. Because in terms of coming to eat somebody's lunch, they're who you're after. So this straw poll, again, reporter, you're sort of taking notes, providing the expert research. I was flabbergasted. I was first off astonished that the chairs would vote, And second, I thought in terms of actually foreclosing dialogue, discussion, and debate, it was quite extraordinary in terms of the process, considering that the working group hadn't completed its work. Other commissioners were vehemently opposed and advocating, in particular those who were focused on globalization, further investigation. So the working group continued and came up with a discussion draft, and all of this is posted on the website, that basically recommended adoption of a modified version of the District of Columbia model rule, and basically said, and this is a potential model that you may want to explore later on, said essentially, restrict law firms to providing legal services, non-lawyers active in the firm, supporting the delivery of legal services. So this is kind of a modified MDP that you already have essentially in place in Ontario, but looking at different ways in which you would configure caps on ownership. So I call this the District of Columbia minus approach. This was as far as the working group was prepared to go, to float something that might have political traction. Comment period for discussion was closed in February, so a very short timeline. There was a meeting in early February 2012. There were only 9 written responses, 6 from individual lawyers, 3 of whom I've quoted there. Those of you who know Larry Fox, a formidable litigator from Philadelphia, from Drinker Biddle, who's been very involved in these issues for an entire generation, basically cautioning against these other tradespeople infecting law firms. There was one submission that talked about non-lawyers routinely failing to respect any ethical guidelines in their business practices, as though people don't complain about lawyers. And Doug Richmond, in a very thoughtful submission, said there was insufficient evidence to support the demand for change. That was an important point, because one of the issues that came forward again as the Commission's work went forward was, where's the evidence of demand? Where is the evidence of demand? Did Steve Jobs ask, where's the evidence of demand for an iPad? No. So in terms of a fundamental philosophical approach, one of the contradictions that was playing out that may be important for your consideration is whether or not you want to liberalize the marketplace and figure out how to regulate it, or say, are you looking for evidence of consumer demand before you are prepared to proceed? That's very much a large and small p political discussion. Finally, dead like dishwater. April 2012 press release, no further movement. But the story's not done. In August 2012, at the ABA's annual meeting, and I was sitting next to Trinda Ernst, former president of the Canadian Bar Association, at this meeting, who looked at me and said, how can this be happening? You had a resolution that was essentially seeking to reaffirm a resolution from July 2000, the multidisciplinary practice debate, that essentially said, we're going to reaffirm that there should be no non-lawyer participation. What was interesting was the language in the report itself, and this wasn't about MDP. This was basically about shutting down any possibility that ABS would ever be considered. The evils of fee sharing with non-lawyers in jurisdiction that permit non-lawyer ownership can have the same deleterious effect on lawyer independence and control, et cetera, et cetera. The American concept and practice of lawyer, sorry, Laurel, globalization be damned. The American concept and practice of lawyer independence is as important to proclaim and advocate throughout the world as is due process and the rule of law abroad. So those lawless jurisdictions like England and Australia just have it completely wrong. Fortunately, at least, that was shot down in flames. Second postscript was the ABA's formal opinion that came out this last August. And I think here is where, if you're looking to the future, there are important lessons to be learned. The Standing Committee was basically invited to deal with one of the questions that remained outstanding. Fine, no ABS or ALPS or MOUSE in the United States, but how do you deal with the reality that you have multi-jurisdictional firms that are going to have lawyers in partnership with lawyers in other jurisdictions where this is permitted? And essentially this formal opinion blasted apart, I think, or at least, they kept talking about the camel's nose under the tent, which came up more times than I care to remember in terms of the dialogue, but this was your wedge in the door, was how are you going to deal with the reality of what's going on in these other jurisdictions? Now you have a formal opinion that American regulators are going to have to take a very careful look at. I think the story out of the United States is one of policy, process, and politics. If you're looking for background information and greater understanding, it's a terrific resource. They did a very broad global environmental scan, but there are 2 things that I'll leave you with. A decade prior, the concern had been about big law. Big law aligning with the big accounting firms to become these behemoths. The debate and the discussion this time was different and needed to be different, and it was really focused on the small practitioners who were fighting for their lives in an environment of internet-accessed services. The further justification from those small practitioners links very closely to your concerns about access to justice and making sure that all Ontarians have access to legal services. The large firms made no submissions and were completely absent from the debate and the discussion this time. It was the small practitioners that I think didn't have the organized voice, but where they were organized merited some further attention. I hope that helps set the stage for what I know will be an important dialogue and discussion for the balance of today. Thank you.
Thank you. So are you ready for our straw poll? Everyone's good to go? I'm immediately going to shake up our questions, gang, because emerging from your presentations, it seems to me that if we flip some of the questions we considered discussing a little bit on their heads, it'll pick up, I think, in a more organized way from what you've left us with. I think the last question I was going to take you to was to take a look at some of the pressures you've described for us. I was trying to keep a bit of a list, and I think we've heard about consumerism. We've heard from Laurel about creative destruction and at least disruption in part on the part of non-lawyer innovators. We've heard about globalization and immigration, other regulators, both domestic and international, and then even some supply side pressures, both from globalized international law firms and also some of the sole practitioners who may be feeling threatened by that non-lawyer innovation. At the same time, Professor Payton has talked to us about what we might call internal resistance. So I had asked all of you to reflect, given that this is the beginning to some extent of our process, on what the lessons are of what you've seen of those pressures and the pattern of pressure and resistance in the settings with which you're most familiar, and give us some kind of key piece of advice, really, to begin not only our day but our longer conversation. So perhaps Professor Flood first, as we haven't heard from you.
Okay. I'm going to pick up on something that Paul said, which was to do with evidence and how you might need evidence of something before you can do it. Clearly, as he mentioned, Apple didn't do it that way, and the problem is that I think with the consumption of legal services, and I'm just going to put it from the consumer's point of view for the moment, if you like, is most consumers have very little idea about what they are actually consuming, what they're buying. Law is typically a distress good. You buy it at moments of need. And it's also it's a credence good too, which is, it's very difficult for consumers to evaluate the quality of the service when it's being delivered and when it has been delivered. And I think one of the things which legal service providers have got to come to grips with is to start looking at the situation from the consumer's point of view and think about what it is that they want, how it should be delivered to them, and how they can engage with them. And I suspect that the canny alternative business structures in the UK have already thought this through and are working out how to do this. And traditional law practices, although good, will find themselves being left behind if they don't do it. Now, just to wrap up, Laurel mentioned outcomes-focused regulation, which we have brought in the UK. And what this means is we don't have a set of rules like the sorts of things which Paul's group has been playing around with without much effect lately. We've moved over to a set of principles. And we have 10 principles, and there are sorts of things like you have to care for your client. And they are really a set of principles, look after the cash properly, and so on. And the key way to deal with them is you're then, as a provider, expected to do a risk analysis plan of how you will deliver your services on those principles. And it's up to you, the provider, to say, you know, depending on the context of whether you're a large firm, a small firm, an ABS, or whatever it might be, this is how we're going to deal with these sorts of principles. This is our plan. And every year, we will provide you with a report on what we've done, what we've got wrong, and how many complaints and things like that, subject to random audits from time to time by the regulators. And I think that actually can be a very constructive engagement. And if the legal professions and legal groups are prepared to go through that, then I think they can improve their situation tremendously.
Thank you. Laurel?
Oh, gosh, I thought you were going to call him Paul next.
Well, feel free.
How to deal with resistance. I'm a big believer in dialogue. I'm a big believer in education. I think it's terrific that you're doing this. I think it's useful. I think that there's really two pieces of the puzzle that I would concentrate on. One is dealing with the services lawyers provide and trying to make sure that they're as good as they possibly can be, so that you don't have the sort of backlash and reaction and government intervention that you've seen in some other countries. I think one of the ways that I would try and accomplish that is to steal the New South Wales Australian idea of appropriate management systems, where it's basically law practice management, but I think a lot of, solos and small don't have the same infrastructure. So you create a mechanism in which they have to go in on these, concrete problems that you've identified and indicate whether they're compliant, partially compliant, and you provide education materials. Because I think there is room for improvement with practice management, and you move your intervention early rather than late. So that's part of the piece with respect to the existing providers, the lawyers. I think the other thing is you just have to remind people, and you have this amazing structure that I didn't know about 2 days ago, with the Legal Profession Act that has access to justice built in. And I think that at least in the US, that part of the conversation often gets dropped. And I think in the US, we're so used to talking about client protection, and we don't really talk enough about client access. So I think, I've learned a lot in the last 2 days about what you're doing in the Law Society to promote access to justice, and I think there's a lot of great ideas we could steal, but I think you just need to keep that on the forefront and ask yourselves whether or not your rules are impeding innovation and access in a way that's not really necessary. And that's not a very specific answer, Pam, but
It's a mindset answer, and that's actually very valuable for all of us. Thanks. Paul?
I agree with John and Laurel, and some of what I'd say in terms of the one guide comes from what I'd already suggested, but I actually want to throw compliments to the Law Society for engaging this dialogue a very different way. I looked back at the Task Force on MDPs report that started off with the Law Society study was premised on the belief that the legal profession should not embrace MDPs, whatever the commercial attractions, until a demonstrable and legitimate demand outweighs the risk the profession's in the public interest. That's a mindset. And so you're opening a dialogue here. You have spot audit processes that are actually perhaps not necessarily by the individual practitioner seen as proactive, but I think in terms of being able to demonstrate to government and to the public that you're acting in the public interest, are important illustrations of how the Law Society, exercising the privilege of self-regulation, is acting in the public interest. But it does come back to this question of how do you focus on making sure that that public interest is at the forefront. And I think that means focusing on, and one of the things that does get forgotten is, when you're focusing on how you regulate the business form, you're not all of a sudden eliminating the responsibility of the individual lawyer to be ethical and in accordance with professional discipline rules. So in that respect, at least, it's not as though we abandon entirely the dialogue about individual practitioner responsibility. You just expand the debate. And I think if you go in with that more open mindset, which your working group's task force, your December 2009 report in terms of summarizing the various pressures got it absolutely right, you're heading in the right direction in that regard. But you have to make sure that you're engaged in that dialogue with a mind to acting in the public interest and with a mind to how you're going to dialogue with government about it.
So we were going to try to find perhaps some good news stories, because you're all more familiar with some of the successes in other jurisdictions, or at least the innovations that there's been some opportunity to process and begin to see a response. And so I had asked you to consider, I mean, the evidence is obviously not fully in, and we've heard some of the risks identified, but what is the story to date? And I asked you each to contemplate one good news story where lawyers, clients, and the public have reacted in a way that perhaps encourages the need and the importance of ABS. So, Paul, do you want to start with that?
I'll go back to the evidence from the District of Columbia, which is over 20 years, and no evidence of complaint, evidence of demand on the supply side from firms that actually want to structure themselves in that way. What we heard at the commission, and what we could not get on the record until it ended up appearing in a Washington Post story later on, thanks so much, was evidence from other firms in other jurisdictions in the United States that wanted to expand into Washington, D.C. and couldn't because New York in particular and others would preclude it on the basis of the fee-sharing rule. So there is evidence of, clear evidence that lawyers are interested, and a 20-plus year track record of no disciplinary issues relating to it. I think that's a very good news story over long term.
That's great. John, do you have one for us?
I think one of the things to note that when ABS has started to be licensed in the UK, apart from one or two examples, the first ABSs were all actually law firms, small ones at that as well, which converted to ABS, mainly to bring other people who were working in the firm into the equity, so to speak. It could be, in one case, it was somebody's wife, but she was the secretary. She ran the firm, basically. But such people as HR directors, IT directors, CEOs, and all these other sorts of people who are doing valuable work, and that I think is actually being really beneficial in the sense that it's opening up a range of careers to people which they hadn't had before, and it also means that again, consumers are finding these kinds of organizations very easy to deal with. Again, I mentioned, I agree with what Paul has said. Certainly in the UK, there have been no complaints registered against ABSs yet. There may be at some point. I'm sure something will go wrong, but so far they're doing extremely well.
Laurel, what's your story?
So my story's from Australia, from New South Wales. And let me just start off by saying one of the things that's wonderful as an academic, but I think actually for all of us, is the New South Wales regulators in Victoria have opened a lot of their files to legal academics so that we have empirical work. And I think that cooperation has been incredibly beneficial and is very useful. So you might just keep that in mind as you go forward with experimentation, because it allows you then to tweak as appropriate. So the regulators in New South Wales cooperated with an academic named Christine Parker, and their study found a decline of 2/3 in complaints against lawyers who had used the ABS structure called incorporated legal practices. I mean, that's incredible. A different academic, a U.S. academic named Susan Fortney, also conducted a study with these same regulators, and she's got some papers that are forthcoming. I have a draft here. And this focused not on complaints by clients, but did interviews with the lawyers who were participating in the ILPs. And the majority of respondents agreed that this appropriate management systems process, where they had to evaluate themselves for compliance, was a learning exercise that enabled their firms to improve client services. 65% of those responding, and then a pretty high response rate, reported that it assisted their firms in addressing potential problems. So I see that as a very positive news story.
Can I just add one thing? I just want to mention one thing, because I think it's the only one I can think of, actually. Our oversight regulator, the Legal Services Board, which also, by the way, publishes everything, good for them, wanted to tackle the problem of whether non-lawyers and lawyers made mistakes, or one was better than the other in some way. And so it ran an experiment, a mystery shopping exercise on will writing. Now, will writing in the UK, probate is a reserved activity. Will writing is not. Anybody can do it. So they got 100 consumers of different sorts, ones who wanted complex wills, others who wanted simple wills, to go and get a will from either a will writing company or a lawyer. And then the wills were anonymized. It was a proper blind experiment. An expert panel was set up of different kinds of will writers, lawyers, and so forth, who then examined the wills on the basis of what they were expected to do, what the consumers wanted. And they found everybody made mistakes. And in fact, the lawyers and non-lawyers made roughly the same amount of mistakes as each other. Sometimes there were slightly different kinds of mistakes, but overall, the error range was pretty identical for lawyer and non-lawyer alike. And as far as I know, that's the only exercise of testing out the quality of legal services in that way that's been done so far. I'd love to see more. And you might want to try that.
Interesting.
Or maybe not.
So rather than me asking more questions, I do want to give us some space to take some questions from the floor. We have 2 mics up. I'd ask that you use them if you have questions or comments, because we are taping. But please, does someone have a question or a comment they'd share? Noel.
Thank you. Given that the accessibility of justice is one of the big arguments we hear for bringing in ABS and changing the regulation, I was wondering if anyone on the panel has any specific evidence about whether justice has become more accessible in England or Australia since ABS. Have prices gone down? Are there fewer self-represented litigants? More people getting legal help from experts?
One of the biggest providers of publicly based legal services, if you like, legally funded legal services, is the co-op, actually. It does an awful lot. Part of our problem is, of course, legal aid has been cut very drastically. There's virtually no civil legal aid left anymore. So what's now being done, what the co-op now does, is since the co-op has a bank, it can arrange loans for your legal services, which are then, of course, paid to the legal services part of it. But they potentially should expand access to justice. It's too soon to say yet. It's only been a year. What you could say is, if you go back to the example I gave of Riverview, for example, which does fixed price legal services, it found within its first year that small and medium enterprises, businesses that required legal services and who were reluctant to use lawyers because they thought they were too expensive, they found a lot of those companies signing up for their fixed price advice line, where you could call and ask as many questions as you wanted each month. And that apparently exceeded demands tremendously. So that's one, I think, situation where it's happened.
There was one other study. I thought I had brought the report this morning. It came out about 2 weeks ago from the UK, talking not so much about that kind, but rather there was a survey done of consumers that said basically, how do you access legal services? And talking about the fact that while we're all kind of friendly, they don't want to approach lawyers. Lawyers are intimidating, lawyers are expensive, lawyers are threatening. You're going to get taken to the cleaners in that respect. And the study basically came up with evidence that with ABS as I'll use the word portal, an entryway into, a pathway into legal services, whether through another kind of service provider or just even in terms of the open accessibility, people were more inclined to approach a discussion about their legal needs that they may themselves not have already identified, simply by virtue of the fact of having another conduit through which to do it. So it's a study that's out in the last couple of weeks. I don't know how comprehensive, but I think as this living laboratory that is the UK going forward continues to study this, we'll have much more evidence. I think one of the things that's important in that regard, and John didn't mention, from the Legal Services Board, they've got a tremendous research funding budget, and that will really support a lot of important work that will need to be done to support it later on.
So I need some materials that are sitting at my desk back there. But I wrote an article called The Legal World is Flat, which was basically a total ripoff of Thomas Friedman, where I took his book, The World is Flat, and then said, does this apply to the legal world? And one of the things that I put in there that I don't remember the exact number, but it was a footnote that cited the growth in Intuit, which makes TurboTax, which is really very popular in the US for filing our federal income taxes. Intuit makes a product called Willmaker. And the sales of Willmaker have just grown exponentially. What that suggests to me is there's an incredible unmet demand. LegalZoom has grown pretty tremendously, and I think you'll hear about that later on. The other thing that I will point to reinforce what Paul has just said is one of the many useful things on the ABA 2020 website is there was information about virtual law firms, and in particular from Richard Granat and Stephanie Kimbrough, who have been around quite a bit. Stephanie Kimbrough is a young lawyer with a family at home, wants to work at home in her slippers. And she talks about she's found this client base that's intimidated to come in to a lawyer's office, that doesn't want to set up an appointment. You know, this millennial generation, they're used to doing everything online. They send a text at 3 a.m. to set up an email. My sense from hearing her speak and those materials, it's not an ABS, but allowing, for example, a non-bricks and mortar office has tapped into an unmet legal need and expanded access to justice.
Do we have another question or comment? Yeah, please.
This may be as much an observation as a question, but to a certain extent, we've already dealt with a disruptive technology within the profession at this end, with in Ontario the introduction of auto no-fault and the growth of the paralegal industry to service that. We've already had to see that and seen, in effect, an alternative delivery of services. We might, in fact, be in a somewhat unique position to assess how successful and how much that regulation of that profession has changed with the creation of the paralegal services that are now monitored on that end. So it's more an observation than anything, but I'm not sure if there's been any comment or consideration of that, given we actually have encountered that at one level already. So I'm not sure if there's any question.
And a report on it now.
I think one of the things that we don't do properly yet is because, most law firms employ a wide range of people, paralegals and law clerks and other sorts of things and so on. We haven't got into the mindset yet that the ethics and so forth ought to pervade everyone and everything. And I think one of the challenges of going down the ABS route is once you start thinking about the ethics of organizations as well as the ethics of individuals, is how do you make those pervasive across all the people working in the organization? Because if you don't get everyone on board in that way, it's not going to work. And so I think from that point of view, lawyers have got to become much more expansive in their thinking about how they want to do that. You might need to do all kinds of vignette setting and planning and experimentation on that to get it right. It's not easy, but it needs to be done. And it needs to be more than just lip service. It's got to be embedded.
Paul, you wanted to pick up anything?
Yeah, one observation in terms of a development almost to the parallel. Washington State right now has actually expanded and is introducing I'll call parallel practice rights in other directions. I'll be speaking at the University of Washington in November. That's something that they've asked specific attention on. So there will be additional jurisdictional evidence in North America. I think it points, though, and John's last comment prompted, there's a real risk. The legal profession has always made this claim to be special. to be important, to be different. We are, yes, professionals, yes, there are other professionals, but we're somehow different because of the ways in which the rule of law and the role we play in the system of justice as lawyers is a proud, long, and important tradition. There is a risk here, a tremendous risk, and this is coming from somebody who's actually said, okay, look, let's take a look at entity regulation, let's look at the way we're getting into the marketplace, that an inordinate focus on the business dimensions of it will allow others to claim that, well, you're just like us. And so in that respect, at least, I think that needs to be an important part of the dialogue. What's been interesting to me in the UK is that that hasn't come up the same way. Now, you've got granted a very different regulatory structure, and you have these reserve practice rights that are different. But I think as you regulate paralegals, as you look at integrating others, that importance of saying, why is the legal profession special, different, and important, is what will in part insulate you from further observation by the Competition Bureau, as a purely defensive practice. But also, I think really it requires us to say, who are we as a legal profession? Going back to John's last slide, and Laurel's. What are lawyers? Who are we as a legal profession? Why are we important? Why are we different? Why do we get to claim that core values that we hold dear matter especially importantly? And I think that's got to be an important part of the discussion.
Laurel, it sounded like you had a quick addition there.
No, I was just thinking of the BC initiative as well with respect to non-lawyers, and hopefully somebody's studying that as well.
Alan, last question.
It's a question that I don't think has been answered yet. And what should be the primary focus of ABS? I've heard a number of different possible focuses this morning: enhancing access to justice, reducing the number of complaints against by the regulator against members of the profession, and even perhaps to regulate services as opposed to providers. Is there something else, or are these the ones? And if these are the ones, what's the most important ones? I'm a member of the working group. I need to know what to take away today when I continue our deliberations after this.
So how about one quick takeaway from each of you? That'd be great.
I would start the other way around. I would start at the bottom up and say, if we're starting with no regulation, what regulation is needed in order to accomplish the regulatory objectives that we have set out? So I would start from figuring out what you need rather than what you don't need.
Paul?
Kind of along the lines that Laurel's suggesting, I'd say, why are you precluding innovation from taking place? And what do you need to foster and encourage it in a way that accords with what you value as lawyers? Start from that premise, and it's a very different discussion.
The ABS is a facilitating idea. It's there to generate ideas, not preclude, not cut off, but to generate ideas. How you do it, that's open to choice and selection.
Well, I think our introductory panel has done a tremendous job giving us the questions. So you will all work on the answers for the rest of the day. But in the meantime, we'll take a brief break. Our panelists are going to stay with us today, so take the opportunity to meet them and discuss with them the scenarios. We're going to break for about 15 minutes, so I'd like to see everyone back by 10:02, please. Thank you. While we're settling, I will introduce our next panel. We put together a second panel that is really made up of some of the thinkers and innovators who will talk a little bit about the range of perspectives on what's driving this innovation agenda and what the benefits might be. And starting that off will be Professors Edward Iacobucci and Michael Trabilko from the University of Toronto. Professor Iacobucci is a professor and the associate dean, and as well the Osler Chair in Business Law, where he focuses on corporate law and governance, as well as law and economics more generally. And many of you will, of course, know his colleague, Professor Trabilko, who is perhaps Canada's leading scholar on law and economics, and who Professor Payton spoke of already this morning. Together, they have written a paper which provides an economic analysis of alternative business structures for the practice of law, and they're going to introduce that this morning. You'll find a copy of their paper on the USB stick that is in your package, so all of you will have an opportunity to consider it more thoroughly later. We're also joined by Yasminka Kalajdzic, who is a professor at the University of Windsor and is one of the Canadian leaders, in my view, in the expansion of legal ethics teaching in law schools, which is happily a growth area. Her research interests include access to justice, class actions, as well as legal ethics, and she's going to share with us how those issues connect with the discussion we're having today in terms of alternative business structures. And lastly, and from a little further afield, we're joined by James Peters. Now, he has a job title which I think tells us a lot about why he's here and is something of a harbinger of things to come. James is the Vice President of New Market Initiatives for LegalZoom.com, Inc. So his responsibilities in that job include directing product and service development strategies, but at the same time working within evolving regulatory structures. So that's a perfect place from which to tell us something about that dynamic, how the legal market is changing, and what that means for the profession. So we're going to start off hearing from Professors Iacobucci and Trubilco.
Okay, thanks very much, Pam. So as Pam indicated, unlike some others who have spoken and will be speaking, I personally am not immersed in the alternative business structure world, but I'm a scholar of kind of law and economics of organizations. Michael Trubilco is also in that area, but has a little more of a deeper and long-standing interest in access to justice and other elements of the legal profession. And so the way we'll structure the talk today is that I will begin just with a brief, I will begin by giving the overview of the law and economics as we see it of organizational structures, and then I'll invite Michael at the end to conclude with some discussions about how this analysis fits within other considerations that matter within the legal profession. Okay, so I won't spend a lot of time describing the whole paper. You have it. That's good, I hope. In the paper, what we do is we introduce some basic economic concepts, and we think there's two that are really fundamental in thinking about the economic potential of alternative business structures, and that is the theory of the firm and theories concerning the economics of capital structure. And I will give a very brief overview of the basics in the talk today. We then turn to different legal structures that are either permissible in Ontario or permissible elsewhere or even conceivable, just sort of providing a kind of taxonomy. And then on the last part of the paper, and this will be the bulk of my focus this morning, we take the analysis of the first two sections and apply them to, we apply the economic principles in the first to these different possibilities in the second. And that's what I'm going to focus on today. I'll do a very brief overview of the economic basics, spend the bulk of my time discussing the application of those basics to alternative business structures, and then briefly touch on policy implications with Michael's help. Okay, so what does the theory of the firm mean as an area? And it's motivated by a very simple question, which is why should economic activities take place within the boundaries of a firm rather than across boundaries of a firm? And it's a simple sounding question, but is actually very difficult to answer. So Ronald Coase, and I've got the transaction cost bullet there. Coase first asked this question in the 30s, actually as an undergraduate student, and he won a Nobel Prize for this work and another work. And he provided some kind of answers about why some economic activities would take place within a firm and others outside the firm. And his focus is this idea of transaction costs. So when you organize an activity within a firm, you don't have to go through the haggling and the difficulties that can result when you're having interactions between yourself and another arm's length, self-interested economic agent. So you can be an ease of coordination that reduces transaction costs. You can just say, you do this. I need this 3.5-minute contract printed up, and you can have somebody print it up. Whereas if you have to hire somebody on the spot market to do that, it would be kind of unwieldy. So the transaction cost story, now of course there's a countervailing consideration, because as the firm grows, those coordination costs can grow within the firm as well. And you'll lose some actually useful information about how you should be coordinating your economic activity. So for example, and fundamentally, you lose price signals, right? When you go to a spot market, you're actually told what something costs. When you do it within the firm, you've got to figure out what those costs are, and that can be complicated. So there's a trade-off, and transaction costs, I think, is a very important consideration in thinking about why economic activities are found within a firm rather than across firms. And I'll just focus on that COAS example, and maybe some of the others that are discussed in the paper, and they might come up in discussion, but I'll just leave it at that for now. Okay. So that's the theory of firm. What kind of economic activities will we have within a firm? There's a second question, which can be related, of course, but there's a second question, which is, how should the firm be financed? Okay? The benchmark for an academic approaching the question, investment bankers don't spend a lot of time on this question, but I think it's a useful benchmark, which is that actually capital structure under certain very restrictive conditions doesn't matter at all, right? Whether you finance with debt, whether you finance with equity, whether you have preferred shares, common shares, the distribution of equity across shareholders, controlling shareholder, widely held, it's all irrelevant under certain conditions, perfect conditions. You have perfect competition, you've got perfect information, a variety of other obviously unrealistic assumptions. But when these assumptions are met, capital structure doesn't matter at all. And that's a useful benchmark because it invites the question, okay, well, why, when we relax these assumptions, why does capital structure start to matter? The intuition for the irrelevance proposition, I've got M&M in brackets, that's not the candy, that's Modigliani and Miller, another Nobel Prize given out for this work. And they came up with this theory of irrelevance, and Yogi Berra captures it well. What do you want, your pizza sliced into 4 or 8? I'll have 8 because I'm hungry. And of course, that's not changing the size of the pizza. It's just slicing it up differently. And that's all capital structure does under these very admittedly restrictive conditions. So what you have to think about is what happens when you relax those restrictive conditions. Why would capital structure matter? Well, there's a host of reasons why that might be so. Some of them will come out implicitly in the discussion, so we'll just flag an example. Managers may have incentives, or those who are actually making decisions on behalf of the firm on a day-to-day basis. Once they have sold claims in that firm, once they've sold shares or they've issued debt, their incentives change. They're no longer, to use the jargon, internalizing all the economic effects of their decision-making, but rather they are externalizing some of the effects to outside investors. So if you don't own any equity in the firm, this will change your incentives to work hard. Conversely, giving equity to a manager will enhance her incentives to work hard because she will realize more of the economic benefits of that costly effort. So capital structure, there's a huge literature on why capital structure matters. In the course of the discussion, we'll touch on some of the other important reasons. Okay, so then our task is to take some of these insights from the theory of the firm and capital structure literatures and relate them to the economic advantages and disadvantages of alternative business structures. And the corollary of this was that as we understand the economic implications of ABS, a corollary must be that if there are restrictions on ABS, there are economic implications of those restrictions, right? And those economic implications will be more or less significant depending on the gains or losses associated with these economic gains or losses associated with ABS. Okay. Couple of preliminary points, and this is a crucial one. We're just focused on economic considerations, so that's and I thank the working group for getting us involved in this. And I think we were brought in to think about the economic considerations that are important to ABS, and others will be focusing more on the ethical considerations. So our analysis can only be partial. I mean, in our view, there's no question that there are non-economic considerations that will matter a lot in this debate about and this unfolding discussion about ABS. We're just trying to supply, one part of the analysis. With that said, Michael will return in the conclusion to elaborate a little more on that. This is something that's come up, I think, tangentially. In our view, it's sometimes put that liberalizing will enhance competition in legal markets. And I don't think we disagree with the outcome that's being described, but we might disagree a little bit with the way that process unfolds. Legal markets are competitive. There's, I think, 10,000 lawyers licensed to practice in Ontario, for example. 20? 20? I was Keep it going. Do I hear 50? Maybe it's firms. Anyway, is it firms? Anyway, I had a number in my head, but it was obviously wrong. Thousands of lawyers and thousands of law firms and thousands of law firms. That's, you know, for most markets, Michael and I are both interested in competition policy. We'd be, you know, delighted to see such a robustly competitive market. What I do think, competition is not irrelevant, though, because, and nor is liberalization of the rules. What liberalization might bring is more, you know, cost-efficient, more imaginative, more valuable means of providing legal services, which are clearly of value to consumers, potentially anyway, and could be of value to lawyers as well, and potentially to investors. Those gains, what competition is important, is I think that those gains are just much more likely to get pushed down to consumers in the context of a very robust competitive environment. So competition, I think, is important because it can help, I think, spread and the gains that this innovation might generate. But as a means to itself, you know, there's questions about, of course, who can practice law, and those you certainly could affect competitive conditions there by completely changing the rules on that. But taking the number of lawyers as given, we're not sure that it's going to have a profound impact on competition per se. Okay. All right, so what I will do for the next 5 to 10 minutes is just go over some of the different forms and discuss some of the economic and disadvantages, beginning with kind of traditional forms. And what will become abundantly clear from this discussion is that one cannot say, oh yes, this is the optimal form in which to practice law. That is not going to be true. It will all depend on the circumstances. Every time that there's an advantage associated with one kind of form from an economic perspective, there's almost certainly going to be an associated disadvantage with that feature of the form. And so I'll begin by discussing the sole proprietorship. Obviously, relatively low coordination costs. So back to that Coasian discussion of, as the larger the firm gets, it becomes more difficult to coordinate activity within a firm. Well, when you have one person, it's a little easier to coordinate that activity. When you have a sole proprietor, the equity holder doesn't externalize the impacts of her economic decisions on other equity holders. She is the equity holder, so she's going to realize a significant share of the costs and benefits. I say significant, it's not necessarily 100%. She may have other investors like a bank that may loan. Unlimited liability that associated with the sole proprietorship is an advantage to the sole proprietor insofar as it provides a kind of bond to lenders and even to clients, right? That if I'm negligent and you sue me, all my personal assets are available to make good on any debt that I end up owing you. That is an advantage in the sense that this becomes attractive, all things equal, for clients who would prefer, all things equal, to have that bond that the unlimited liability can provide. Similarly with lenders, there's the commitment that provides is welcome. Now, there are, for almost every advantage, as I say, there's a corresponding disadvantage. So low coordination costs, well, you've also got pretty limited economies of scale if you have a traditional sole proprietor. And limited, and I think this is important, especially maybe when we're thinking about ABS, you've also got very limited economies of scope. So you've got a sole proprietor providing a certain kind of legal service. If she's going to provide other kinds of legal services, she either has to become a generalist, which has its own costs, or she has to engage, and this is where the transaction cost parenthetical comes up, she has to engage in some sort of arrangements with other firms. And of course, there's ethical rules about referral fees, and so that, I think, even increases the transaction cost that much more. But the idea is that there'll have to be, if you're going to be a specialist, it's going to be, clients that have multiple needs will have to be addressed by multiple firms, which will increase transaction costs. Being the sole shareholder is going to expose the, I shouldn't say shareholder, being the sole equity holder in a sole proprietor exposes that sole proprietor to more risk. Right? So if the firm is going to take on risk, she's the one who's going to bear that risk. Right? So if there's going to be some investment in some sort of technology application, well, she bears all the risk associated with that investment. It's tougher to diversify. Capital constraints, a related point. Capital constraints, you've only got individual wealth to draw upon for equity financing, right? And that too will limit the capacity of the sole proprietor to make kind of risky investments, or even not so risky investment, which is important. And of course, I should say on the risk side, the unlimited liability advantage to the lenders is exactly a disadvantage for the sole proprietor, right? In the sense of that she will be exposed to risks and have her personal wealth at stake in a way that is, all things equal, not desirable for her. Okay, so then what we did in the paper and what I'll just try to do in the talk is discuss different forms relative to the sole proprietor. So you can move from the sole proprietor all the way to kind of incorporation. And so a partnership is like a sole proprietorship, but with more of them, as everybody here knows. So you're going to get greater potential for scope economies. You could have different kinds of, you could have the, litigators and the corporate securities people in the same firm, something like that. So as a partnership grows, there is more scope for specialization, and that means less need for sort of these either formal or informal arrangements with other service providers when a client comes with multiple needs. I think it's important that this partnership at least has greater diversification potential, right? The more partners there are involved, there's going to be the greater, there's going to be less exposure for each partner to the risks of the firm, because there's going to be different experiences, business experiences across partners, right? So if you have a bankruptcy lawyer and a securities lawyer who are partners, they have sort of home-brewed some diversification. Bankruptcy is going to be busier, and sometimes in the business cycle, securities are busier at other times. The joint and several liability is as an advantage in the same way it provides a bond, and joint and several liability is that much more powerful a bond, I think, to clients and to lenders. Disadvantage, as the firms grow, the coordination costs within the firm will also increase. Smaller equity share per partner as the firm grows, reduces their stakes in the economic performance of the firm, all things equal. All things equal is important because there's ways around this, but that's going to affect the incentives to work hard. There may be risks associated with joint and several liability. I think in the interest of time, I'm going to skip ahead. We in the paper discuss business corporations with limited liability, but restricting it first just to lawyer shareholders. Just to, I think, distinguish between the advantages of incorporation with an ordinary plain vanilla business corporation. There's the advantages of that form with lawyer investors, but that are quite different when you can have a non-lawyer investor. And in fact, business corporations with limited liability, in a context where we already have LLPs and professional corporations, this move is not going to be that significant. This kind of alternative structure is not necessarily that significant. There might be a little less risk associated with incorporation relative to even something like a professional corporation or an LLP, but it's not going to be a significant difference. Where I think the ABS really becomes significant is when there's non-lawyer ownership. And there's both theory of the firm and capital structure reasons to imagine that this is going to generate, I think, some economic advantages. So the theory of the firm advantages, there's a number. So one would be that you could have different kinds of service providers within a firm. This is just the kind of NDP story. You could have an accountant and a lawyer, and the way an economist would think about the gains of having them in the same firm is to say this is just kind of lowering transaction costs. You can coordinate the provision of those services within a single firm and not have to go and engage in kind of complicated referral arrangements with outsiders to service your clients' needs. I think specialization is another very important theory of the firm advantage associated with non-lawyer, at least potential advantage associated with non-lawyer ownership. There's no reason to think that all lawyers are going to be entrepreneurs, but the way our structure is set up is that it really sort of pushes them to both run a business and provide legal services. Well, it's easy for me to imagine that there are lots of entrepreneurs out there who don't want to provide legal services, but if partnered, and I'll use that word loosely, but if partnered with a lawyer, may be able to provide valuable entrepreneurial skills and services to that practice that the lawyer herself is either not interested in providing or is not as well equipped to provide. So I think when we think about the sort of economies of scope, it's not just about multidisciplinary practice. It can even just be the way the business is structured. Some people will be the business people, and other people will be the lawyers within this structure. And I think that's a real potential source of gain. There are disadvantages associated with non-lawyer ownership. There may be more coordination costs within the firm, and there's certainly discussion of culture as potentially being in tension with one another when non-lawyers invest in the firm. One of the advantages, I think, of referrals of your clients to other specialists is that there may be some credibility associated with that, because you're not a kind of residual claimant in the services that this alternative provider is giving. So there may be some reduction in the credibility of referrals if everything's within a under a single roof. So there of course will be advantages and disadvantages. But so that's the sort of theory of the firm, thinking about what economic activities are structured within the firm. The second thing that I want to focus on is the capital structure associated with a business corporation where non-equity investors are permitted to invest. And the capital structure advantages, I think, here are significant. At least potential advantages. We don't make any claims empirically. Let me be clear. We're just sort of pointing out some of the ways in which we think that these things could unfold, but we don't make an empirical claim. The capital structure advantage of a business corporation with unrestricted access to non-lawyer investors is that you've got the greatest potential to raise equity capital. You don't have limited capacity of the partners to invest their own personal equity. For example, there's greatest diversification, right? So rather than having a sole proprietor where she bears 100% of the risk of that firm, you could have a publicly traded law firm where each investor may be bearing a very small percentage of the risk, and moreover can use the assets, because she only has a handful of shares in the company. That investor can invest in a variety of other companies that help diversify her risk across a portfolio. How does that cash out? This greater access to capital and the greater capacity to diversify. Well, that could cash out in one of two ways. One, there's just less risk borne by the lawyer. But another, and I think quite plausible way in which that would manifest, is that there would be greater potential for risky investment, right? You're going to have greater access to capital. It's going to be less costly as a consequence of this risk diversification. And so it's going to be just greater potential to make these kinds of investments. Disadvantages: lawyers take a widely held law firm, they may not have the same sort of incentives to make decisions that increase the value of the firm, because a lot of those benefits are realized by other people, right? It's always going to be a problem associated with a widely held firm. It would be no different in the legal structure than in others. One possibility I put with the question mark is maybe something like hybrids, something like a franchise system where the lawyer bears a significant part of the gains and losses associated with some local franchise, but is also associated with a much broader franchise system, which works at investments in things like their brand and web applications and the like. And quality solicitors in the UK, at least as I understand it, seems to approach this sort of model, something like this model in any event. Okay, so there's no optimal structure across all across all firms. It's going to depend on circumstances. But this doesn't mean that economics has nothing to say about liberalization. Rather, I think it should be taken to say, well, it's not obvious that there'll be gains, and this actually goes back to something Professor Terry, I think it resonates with something Professor Terry said, which is there may or may not be gains, but let's find out, right? It will depend on the circumstances, whether there will be significant economic advantages associated with these different forms. Liberalization at least creates the potential for these economic gains to be realized. I don't know how to conclude. Whoops, we're getting different with the way the bullets are coming out. But in any event, I'll stop there. But what I'll do is I'll ask Michael to say, well, actually, before I ask Michael, just two things. Liberalization clearly has some economic advantages because it just increases the opportunity set. Right? So the traditional legal structures have advantages to them, and they may well persist. And this is a bullet that I think is worth highlighting, and this is from Noel Semple's pointed out that apparently in New South Wales, the number of small practices has actually grown in the last 10 years, which I thought was quite interesting. So it's not to say that traditional structures are necessarily, in all cases, going to be, the way of the dodo if there's liberalization. But at the same time, there clearly is some potential, and we've already seen that in other jurisdictions. There is a potential for experimentation and success in alternative forms. So with that, I'll turn it over to Michael to conclude.
As Ed pointed out, our mandate from the Law Society in writing this paper was to focus on the economic implications of alternative business structures, and we set aside ethical and non-economic issues. But I do not want to let the session go by disowning any interest in these non-economic issues. And in particular, I want to focus on the connection between equity and efficiency. I've taught and written in the law and economics area for 30-some years at the University of Toronto, and often students say, well, you're sort of an efficiency obsessive, right? That's the only thing you care about. Well, first, that's not true. I care about distributive justice and corrective justice, and more specifically, access to justice. For the last 15 or 16 years, I've been associated with various efforts to improve access to justice in this province, starting with the McCamus Commission Task Force on Legal Aid Reform in the mid-70s, where I was research director, the Holden-Kaufman Task Force on Revising the Legal Aid Tariff 6 or 7 years later, my own review of the legal aid program in 2008, and then most recently the Middle Income Access to Justice Project at the University of Toronto, which yielded a book by that title. So I'm passionately committed to access to justice, right? Equality, not just formal equality, but functional equality before the law and the rule of law for completely non-economic or almost completely non-economic reasons. So I don't apologize for this dual commitment to equity on the one hand, but you might say, well, where does efficiency fit in? Have you abandoned that? Have I sold Ed down the river? No, because in these access to justice issues, I often found that passionate proponents of equality before the law and access to justice refused to confront the challenges of scarce resources, right? How are we going to vindicate access to justice, equality before the law? What kinds of mechanisms make sense within a constrained set of resources in terms of realizing this ideal? And here it's impossible to avoid efficiency-type analysis. What is the most productive, innovative use of existing or imaginable resources that would enable us to get closer to this ideal? So people who say the rule of law or equality before the law or access to justice is a pearl without price, for me, are talking nonsense. How can it be a pearl without price, that resource constraints don't matter, that efficient, productive, innovative deployment of constrained resources is irrelevant? So I think there's no tension between equity and efficiency. Any sensible person thinking about access to justice issues and efficient, innovative, productive deployment of existing resources has to bring the two issues together. So there's no inconsistency, no tension, and any single sort of one-dimensional view of the world, I'm only interested in equity or I'm only interested in efficiency, really is missing where all the action is. Thank you.
here. One moment. Should be one that is J. Peters. All right. There we go. Okay. Thank you all for having me. I think it's an interesting point brought up this morning that as people may be well aware, there was not much interest in talking to us when the U.S. was looking at these considerations, which I think is unfortunate. You know, it's a little bit strange to take a look at these kinds of changes and not talk to other players in the field. So I sort of, you know, applaud what folks here are doing on this front, because it really seems like a good sort of measured approach at looking at this. With that, I will say I'm not here to scare anybody. Just to provide some basic information on the status of innovation in legal services, and as someone from my position, give my 2 cents about where I think it's going. I'm not used to staying still when I present, so for the sake of the recording, I'm going to do my best. There are handles here, so I can hold on. So just a quick overview of what I'm going to talk about. In a very basic sense, I want to talk about the fact that there really are two markets in legal services as I tend to look at it. Go over some recent developments focusing on one of those markets, with highlights regarding the state of funding in legal innovation, basically. Go a little bit on future directions as I see them, and talk about this last question, which is where are the law firms in this innovation process? So with that, when I talk about two markets, I mean in a very, very broad sense, corporate law and consumer and small business. So the folks who work in large businesses have a different set of needs in a general sense than people who are opening up their own small business. You also have sort of fundamental differences in things like information asymmetry, stuff along those lines. So when you're working with a big business, you've got, you know, theoretically a general counsel or people who are very experienced in business and understand from a starting point a lot better what their lawyers are talking about when delivering legal services. From a small business perspective, you generally have folks who are, you know, really trying to get going. A lot of times, you know, we talk about it in terms of launching or starting your dream, you know, working for yourself. It's something that's very personal and very different than working in a legal department in a corporation, from my opinion. So my focus is on consumer and small business. That's what we do at LegalZoom. That's what I know better. I've got a few notes about corporate in here as well, but the majority of what I'm going to talk about is that smaller market. So in recent developments, I steal this a little bit from a presentation that Professor Dan Katz gives, but taking a look at where legal startups have gone. There's a site in the US, I don't know how many of you are familiar with it, it's called AngelList. It's companies that are starting up and sort of interested in being out in the angel investor space through VC funding, things like that. So if you went back to 2009 and looked up startups that self-identified as legal in nature, you would have found 15 companies. Today, that number, yesterday, technically, it was 305. So that's a pretty significant level of growth. You know, it's still a small-ish number in the overall world of startups, but as a sort of just percentage growth, you're looking at a pretty big change. In terms of where those companies are going for financing purposes, things of that nature, so there's another website in the US called Crunchbase. Takes all the TechCrunch posted companies and analyzes the funding data, things of that nature. And take a look at 306 that were listed in 2012 on that website. Of those, 23 companies were funded to some extent. That's about 7.5%. Total funding there, $104 million in US. Average funding of 4.5 million. That is a skewed number because there are a few companies that got pretty big rounds, and lots of companies, lots of the 23 that got very small financing rounds. So I think in a general sense, I mean, only 15 listed in 2009, 23 actually getting funding in 2012. We're still dealing with relatively small numbers, but it is meaningful, and it's a meaningful change from my perspective in terms of what's happening. When you look at some of the traditional metrics, though, of sort of companies really making it in terms of going legitimate, if you will, so that tends to be a focus on things like getting acquired by a bigger company or having an IPO. Those numbers are not so great in legal. We've got one acquisition in 2012, and so under 1% there, and 0 IPOs. So even with lawyers, I don't need to do the math on the percentage for that one, I think. So it's sort of to be expected. It's a relatively early stage for legal startups. But at the same time, I think it's a little bit indicative of some of the challenges that legal innovation faces. So you take a look at things like, how do you ultimately extract the value from a company that's providing innovative legal services? It's a risky proposition. You can't blend fees. You can't share fees with lawyers. You've got a lot of sort of unanswered UPL questions in the US in particular. So you think about this from a large scale beyond sort of angel and VC funding and say, do I want to put a lot of money into acquiring a company that is subject to regulations that even the people who regulate it don't understand? Maybe not. So I think we've got good progress, but we're a ways away from being sort of a legitimate legal innovation economy in the US at least. With that, I want to go over so a few subcategories of what I consider the consumer and small business market. First one here is what I'll call legal forms plus. So this is companies that are known for legal forms, but really provide a broader suite of service as a general matter. I've got LegalZoom on here, Rocket Lawyer, Clerky, which is a relatively new one, and on the bottom there it's Docracy, and I tacked on a little flag because that's Canadian folks who started that up, even though they live in New York now. So you've got some representation in the slides here. So there, I will caveat this also, there are obviously lots and lots of other companies out there. I didn't want to make everyone sit through me trying to go through 305 of these, so I just have a highlight reel of sorts. So, and what I looked at was companies that have had either good experience with sort of what are considered very legitimate incubators of startups, so they've got good connections and good resources at their disposal, or have gotten some sort of noticeable financing in the last couple of years. LegalZoom, of course, as a starting point, has not had any major financing this year or last year. We postponed our IPO in 2012 for market conditions reasons, but as was mentioned earlier, if you want a good little sort of insight into how these things are working right now, I'd encourage everyone to go over to the sec.gov website and actually read through our S1. It's probably of a fair degree of interest to a lot of folks in this room. But in terms of a couple sort of highlight numbers on there, we had $156 million in revenue in 2011. $96 million in the first half of 2012. So it's a pretty meaningful business. If you that's my nice way of saying that. 20% of all LLCs in California were formed using our website. So if you think about this in terms of a sort of purchase path that tends to introduce people to lawyers and law firms, there's a lot of folks who are going through a sort of non-traditional channel and are not getting introduced to those firms at this stage where they might have otherwise if the firms were more actively involved in this kind of work. Rocket Lawyer has gotten a lot of attention because Google Ventures happens to be one of their financing rounds. So a lot of times you'll hear them as, Google is coming to take away your practice. It's a pretty small bit of their investment, but it is meaningful in just brand. But last year they did get another $15 million, or this year, over $50 million total of investment. And they were that one, the one recent acquisition. They acquired a company called Law Pivot earlier, which is a legal Q&A site, basically. So big developments there. The one thing that both LegalZoom and Rocket Lawyer do is they sell these forms, but they also connect people with lawyers in their networks. So Rocket Lawyer is more of a marketing sort of setup where they say, we'll connect you with a lawyer who's agreed to provide certain discounted services. LegalZoom actually works with a legal plan in the US in 42 states where we have state by state particular firms that provide the services under the legal plan. So one thing to keep in mind as you look at sort of the state of competition with the regulatory structure as it is today is there are ways basically for non-lawyer companies to provide services that allow both legal document creation and lawyer review at a price tag that is quite low. So we're talking under $200 to get a will, have it reviewed by an attorney, have a consultation. It's a big change in that respect. I think too that potentially one of the biggest impacts that these companies will have on the legal services industry, at least in the US, is in terms of information that is out there in the customer's hands. So the WebMD example came up earlier. I think you've got, on the one hand, people who know a little bit about their legal situations and can go in a little more educated. I think we've got a long ways to go on that front. On the other hand, you've got price anchoring, I think, that's taking place. So you've got legal services that nobody really knew what they should be paying for a very long time. And now you've got companies like LegalZoom doing massive marketing campaigns that are basically telling you that your starting point for these services should be around $100. So that's a different mindset when somebody's been viewing that kind of marketing for a few years and walks into an office and hears a typical lawyer's rate spiel, if you will. So keep that in mind as well. Clerky and Docracy, I think, are interesting because they are sort of the new wave, in my opinion, of legal startups in small business. And they are coming out of legitimate startup sort of grounds. So Y Combinator for Clerky, TechCrunch Hackathon for Docracy. And they're really focused much more on the sort of true startup scene for small businesses. So small businesses that are getting going and are anticipating looking for funding is really where they're aiming. So where LegalZoom has traditionally done more of a get your business started and set up properly, these companies are saying get your financing documents, et cetera, here. So it's a different realm to some extent. Next one is branded networks. So this is where the lawyers come into play to a large extent. And these are all companies that basically connect consumers and lawyers. So big problem, in my opinion, for lawyers providing services in an online world is that it's extraordinarily hard today to market yourself. It's very expensive. It's as much as you hear about like local focus on web search and things like that, it doesn't really work very well yet. So you're competing as a small firm in a small location, potentially, with every legal startup that's advertising online as well. So you likely don't have the search engine optimization or marketing skill set internally, and you probably can't afford the pay-per-click advertising rates as they are today. So one way to work with that is to say, well, let's try these other companies that connect people with attorneys because they have broader reach and sort of, I guess, economies of scale, if you will. And there's been a lot of interest in financing in this realm. So Total Attorneys had a $15 million round in 2012. Legal Reach is very new, but they just got almost $1 million. Up Council, 1.5 million just this week. LawPal, small round so far, 650,000, but it was reported on Legal Futures this week that Peter Thiel of PayPal fame is investing. You'll see in this kind of space a lot of folks who are sort of a colloquial known as PayPal mafia investing in the space. They tend to have interest in this kind of area for one reason or another. And it may be because of the success that they've seen with the online dispute resolution in their own environment. But more money comes in from there. Lawgives.org, that's the one .org on the list. It's a Stanford StartX company, so they're based out of Stanford and trying to get going. I think the one thing that you really see in this arena is a movement toward a couple of things. One is niche practices, so much more specific. Total Attorneys hosts a whole bunch of sites that are focused on one particular area of practice. Also, higher level counsel. So Up Counsel is much more of a high-end service. So not just the typical lawyer directory, but people who would have been considered sort of out of the reach of these types of networks in the past are getting involved in them. And then marketplaces is the sort of final step, and that is flat fee services. So a brand that presents firms that are providing flat fee services for a variety of legal needs. Next up, this is where I think it starts to get very, very interesting and much tougher from the ethics point of view. So mediation, dispute resolution, and more. This is just a small sample here, but Modria is the company behind the eBay online dispute resolution. They have got $5 million in July. 60 million disputes settled online, I think, is what they claim, and extraordinarily successful. So they managed to basically automate disputes between two parties to a degree that makes most people happy when they get done with the process. So that's a pretty interesting shift, if you will. Weavorse is very new. It's another Y Combinator graduate. They basically are taking a hybrid model where it's sort of online systematization combined with actual people who help do the dispute resolution piece of it to work people through divorces in a truly uncontested, more mediation type setting. And they just rolled out fairly broadly, I think this month. Lex Machina, I don't know how many folks have heard of them, but this is where it kind of starts to get crazy stuff. Nutty things that are hard to understand. So they've gotten some good investment, $10 million total, 7.2 this year. They basically take a whole bunch of data around a patent and possible infringing patent cases, and they put it into their system, and they take stuff like the actual patent documents, the judges involved, the companies involved, and produce results that tell you how likely you are essentially to prevail in a case. And they are extraordinarily accurate. So this is the kind of work that starts to encroach on true sort of counseling and legal advice. It's really, really interesting. There are a few people working in this field. And Lex Machina just happens to be the one that's gotten money and some press so far, but I would expect to see a fair degree more of that in the near future. It's my one ode to the corporate side. Everyone's familiar with Axiom, I think. But they are a very, very big player. So raised $28 million this year, over 1,000 employees, $130 million in revenue in 2011, greater than 70% compound annual growth rate. So they are really, really moving up in the world. On the corporate side in particular, there's a lot of debate about them. You get people making claims that they're going to continue at that growth rate and be the biggest provider of legal services by 2018. That'd be a pretty phenomenal run for them, but who knows? Maybe they can pull it off because they're smart people and do a lot of good, interesting work. And there's a lot of dispute about the fact that they sort of present themselves as a law firm. So we'll leave sort of that piece of the puzzle out of it to some extent, except to state that if they were in the consumer space, they would not be in existence today, I think, the way that they brand themselves. I think they benefit from the fact that they're working with in-house legal departments, so they are given much more leniency in how they present their services. And somewhat understandable, because they're selling services to lawyers who are, effectually supervising those services. So that leaves me with the last question, which was, where are the law firms? I originally had, where are the lawyers? But as I looked at this, I realized that the lawyers are basically leaving law and joining the startups. So that's where the lawyers are. They've recognized that they can't really practice in the format that they would like to, so they just stop practicing and do a legal startup. There are some law firms that are trying some very innovative things, but they're basically forced to do what I generally call just a two-tier structure. So they're forced to have a law firm on one hand, a business process outsourcing company on the other hand, and the two of them have a relationship. It's very intertwined, but they have technically separate legal entities. So the business process outsourcing arm is allowed to do things a law firm would not be, and it's allowed to have non-lawyer owners or partners, and then the law firm itself exists in the typical law firm world. So to me, this is sort of telling, because I think that what we're effectively doing as a profession is forcing people who want to innovate into being unregulated, which could be fine. I don't really know if that's the best way to do it or not, but I think that's what we've decided as a profession to make happen. That if you want to provide innovative services, you're going to have to drop out of traditional legal practice and do it outside of our purview, basically. So with that, the future of law and where I see it going, I'm always disappointed that I don't see this picture at more conferences, because it's like the world's greatest role play game from the 80s about the future of law. I'm not sure how so. I don't think the future of law enjoys or involves giant wildcats necessarily, or glowing rods, but I do think we're looking at some changes coming. As I mentioned in some of the other the examples, I think you're seeing a lot of movement toward upmarket practices that are non-traditional. So innovation in the realm of sort of highly specialized people who have very good pedigrees and backgrounds, who are now moving out of traditional practice and going into startups that provide sort of alternative types of legal services. The other is niche. I think that's around very specific types of businesses. You're seeing more startups that target, people who do a very particular kind of business. Also, really a focus on those investment-seeking startups. I think that is where a lot of the attention is going right now. I think you'll continue to see more niche practices in that realm. And then finally, right now, the future in terms of money is all marketing. Because of the restrictions that are in place, the vast majority of startups and folks who are getting money are basically providing front-end marketing services for law firms. So, and they might be doing a little bit more innovative work in terms of tools to connect you and manage your cases once you get connected. But up front, they're basically marketing the law firm services. I think this gets to an interesting point too, that so if you're not ready to drop out of law altogether and do a startup, and you want to provide innovative services, you almost always end up having to go with a third-party provider. So you end up outsourcing some of your requirements that way. I think that's a real thing for regulators to consider. Are you happy having people outsourcing that to third parties? Or should they be working a bit more with it directly on their own in a way that's feasible? If they could have more intertwined relationships, or possibly even have partners on hand who do tech development, things of that nature, they might not have to just drop it out to one of the 20 new startups that's providing these services. That is my take on legal innovation today and where it is headed.
Hello. I want to start by correcting something Pam said in my introduction. I don't claim to be a leader in legal ethics training in the country. That accolade is shared by lots of my colleagues and friends. I came, though, to legal ethics and to researching and writing about legal ethics as a result of my research and focus on class actions. And so I do claim to be one of the few, if not the only academic so far, who's been looking at legal ethics in the class action litigation space. And it was from that space that I also came to start thinking about this particular topic, litigation funding. And in a way, it's a departure from everything that we've been talking about so far, in the sense that the symposium is designed to get us thinking about what ABS might look like in the future. What kinds of business structures do we welcome? Do we wish to perhaps introduce or experiment with? Well, in fact, ABS is here in Ontario, up the road. Litigation funding is a species of litigation, of ABS rather, but the very fact that it is largely not talked about until quite recently. It is, as far as I can tell, and I have some smart colleagues who looked at this issue as well, it is completely unregulated. And perhaps it's because of what we just heard, which is when you have restrictions in a particular regulated market, you force innovation outward. So I'm going to try and do a lot in the 15 minutes that I have. So I'd like to bring us up to speed as to what litigation funding actually is in our own backyard. Give you some ideas as to why this innovation has taken place. And then get to, I think, the meat of it, why I was invited, and thank you for inviting me, to give you a brief overview as to some of the arguments in favor and opposed to the advent of litigation funding, which necessarily brings us to a topic that I know is important to everyone in the room, starting with the Treasurer, which is access to justice. So what are the access to justice implications of litigation funding, both negative and positive? And then leave you with some questions as to possible regulatory responses. So litigation funding has lots of different names. I've put some of those on the slide, but there are actually more. And the nomenclature actually matters to some extent, because I think when you start to talk about litigation funding, which is the term I'll sort of keep coming back to, but when you start talking about it as litigation investment, you're really getting to the heart of what it is that we're talking about. It is financing of litigation for profit. I'm specifically narrowing the conversation to the private sector, but of course there are public entities which provide funding. And so we're talking about third-party litigation funding. So entities or persons who provide financing or other financial support to litigants, and those entities or persons are not themselves, strictly speaking, parties to the litigation. And I'm excluding from the definition the list that you see in the third bullet. So lawyers who work on contingency fee arrangements are, in fact, third-party financiers of litigation. But I'm putting that to the side. That's a debate that we had in this building several years ago, and is now, I think, firmly put to bed. Liability insurers are another form of third-party litigation financing. Organizations that fund public interest litigation, of course, are another version of third-party financing. Legal aid plans, public funds, so in Ontario, the Class Proceedings Fund also provides financial support to plaintiffs in class action litigation. But I'm focusing my remarks on private sector financing, where the only interest of the funder in the lawsuit is to make a profit on the investment, full stop. That's the only interest. And so the litigation proceeds can be a security debt, or they may be in the way of a formal assignment. So in some jurisdictions outside of Canada, I don't know if it happens in Canada, and I'll get to that in a second, but there are actually formal assignments of claims by the plaintiff to the funder. That's the form of the contractual relationship that takes place. But in Ontario, at least from what I've been able to tell in my research, it's primarily a contractual arrangement under which the funder has a first or second charge on the proceeds of the litigation, proceeds being either a judgment if the case goes to trial, or more often than not, the settlement of the litigation. The forms that the litigation funding can take place are predominantly, but this is an area of growth and innovation, so I don't expect that this list is complete, but primarily it takes the form of either a loan agreement, an investment contract, or, as I said before, the assignment of the legal claim. And litigation funding is currently taking place, again in Ontario, in class action litigation. Plaintiffs are the recipients of the litigation funding. I don't know of any defendants in class actions who are utilizing litigation funders, but it would be hard to find that out. Personal injury action, and that's where litigation funding actually was born in Ontario at least 10 years ago. There were firms that were in the business of lending money to plaintiffs with small personal injury actions. And that market has been likened by some of my colleagues who write in this area as very much like the payday loans industry. The ugliness of that industry as well as the potential benefits. Very similar arguments in that we have people who are extremely vulnerable, but who are unable to finance even just the disbursements of their personal injury litigation. Forget about the fact that some may not even be able to secure the services of a lawyer on a contingency fee basis. Even those contingency fee lawyers will require plaintiffs clients to fund the disbursements, and in situations where the litigant simply doesn't have the resources to do so and can't get traditional financing through our financial institutions, will turn to these so-called lawsuit lenders for money to pay for the disbursements, or sometimes, in fact, just to pay the bills, to pay their mortgage, to be able to live until the lawsuit is resolved and they get some money from the resolution of their claim. So personal injury action litigation funding is a very different animal, I think, than what we're seeing in terms of sophisticated parties in the class action world contracting for funding of really large actions. And then third, I'm told that in international commercial arbitration, litigation funding is also fairly well entrenched, but again, there isn't a lot of information coming out of Ontario, despite my best efforts, to better understand how that works in our jurisdiction in particular. And that's the point that I will have already made now twice, and which I'm afraid I'm going to have to keep coming back to, and that is that there really is a dearth of information about how this industry operates in Ontario. It's the same story in the United States. I mean, there's a little bit more information because we heard earlier, I think from Professor Payton, that the ABA's 2020 Commission, one of its working papers was in fact about I think it was called Alternative Litigation Finance by two very well-respected legal ethics scholars, Brad Wendell and Anthony Seebach. And so they did a very good job of trying to do an environmental scan, if you will, of the litigation funding market in the US and elsewhere. But really, there isn't a whole lot that we can find on the public record about the kinds of contractual arrangements that are entered into, what the terms are, the rates of return, and so on and so forth. I think it's telling, in the last month, I've received 2 phone calls from journalists looking for really basic information about how litigation funding operates in Ontario. I received a phone call from a Toronto law firm, a medium-sized firm, looking for information because they are considering doing business with a litigation funder and aren't sure about everything from the ethics of doing so to the legality of the practice. And I received a couple of phone calls, including another email yesterday, from a New York-based due diligence firm who is working on behalf of a hedge fund that wants to enter into the Ontario market and needs to get some better information. And, you know, I'm very flattered that they would call me, but me? Like, this is the level of transparency of the market that you have to come to me for that information. So one of my clarion calls at the end of all of this is that we really do need to do a better job of reaching out both to the market players as well as the law firms and lawyers who are using these services to find out exactly what's going on. So the contracting parties, and this goes back to sort of what does a litigation funding arrangement look like? In the personal injury context, it's a contract between the funder and the individual plaintiff. In the class action context, it's again an agreement between the funder and the representative plaintiff, with the caveat that in a study I did last year, in which I interviewed 8 plaintiff-side class action lawyers about litigation funding, a few of them said to me, well, technically, that's the nature of the contractual relationship, but in reality, the arrangement is between class counsel and the funder. And then, of course, there are also, especially in the United States, a whole range of contractual relationships that involve not clients and funders, but rather lawyers, law firms, and funders. And that's not only with respect to a particular piece of litigation, but increasingly in a portfolio. So creating a portfolio of cases being run by a law firm in which a particular funder will have an investment interest. So I say that because I think that in each of these different scenarios, we probably have different ethical concerns and different forms of regulation may be contemplated depending on the nature of the relationship. So I guess this is the part that will wake you up. I know it's almost lunchtime, so here's some numbers to wake you up a little. The rates of recovery for the funders in Ontario are anywhere between 7% to over 60%. And for all of us who've looked at payday loans case law, that number should ring a bell. That is the usurious rate of interest that's prohibited by the criminal code. What little we know about the personal injury sector of litigation funding and we only find out about this stuff, frankly, almost by happenstance. So in the course of satellite litigation, for example, a motion for costs, if you look carefully, you can find some tidbits of information about the kinds of rates that are being charged on the loans by funders. So one of the cases that's now become quite often cited is Giuliani and Hulton, a 2011 case, which was a motion for costs following a successful trial. The plaintiff got, in the personal injury action, damages in the amount of $375,000. And in the motion brought by her lawyer for costs from the defendant, the lawyer claimed the interest on the loan with a lender in Ontario as a recoverable disbursement from the defendant. And it was in this way, as I say, happenstance, that the judge explored the nature of the relationship between the funder and the litigant. And it turned out that the plaintiff had been charged $92,000 of interest on a $150,000 loan that had been taken out the year before. So that was an effective annual rate if my math, and admittedly I'm a lawyer so my math is bad, but very close to 60% interest per year effectively. Ed's going to tell me if I'm wrong about that. a state of affairs that, not surprisingly, the judge, in dismissing that item as a recoverable disbursement from the defendant, called an unconscionable transaction. Quote, "It is turning the world on its head that this is about access to justice." And continuing, "It is difficult to believe that a lawyer would refer a vulnerable client to such a lender," end quote. There are other examples, again, that you find by accident. One, a more recent case out of BC called Fontaine and the Attorney General, where the court found that dozens, in fact hundreds of loans and advances had been made to residential school survivors in the IAP process, the individual assessment process, where a particular firm, one firm, had referred 170 or so of these claimants to a funder who gave out 373 loans to those people at rates that exceeded the criminal interest rate in the code. So this is extremely lucrative stuff for funders. In Australia, where the practice is very well entrenched and very reputable, there are Supreme Court decisions in Australia that have blessed litigation funding as a legitimate form of financing to increase access to justice. The rates there are between 30 and 40%. In the UK, again, from in one article that I read, it's the higher of 25% or 3 times the funds committed. In the US, in personal injury litigation, it's between 5 and 20% rates of return on amounts invested. And again, in Canada, it's sort of all over the map. The size of the market in the United Kingdom is estimated to have a market cap of 350 million sterling. In Australia, there are 5 major funders, 2 of which are publicly listed. One of the biggest, if not the biggest, IMF, coincidentally not the International Monetary Fund, but getting close, has earned $250 million in fees in the last 10 years. And in the US, according to a New York Times article in November 2010, the total investments at any given time in that market exceed $1 billion. So this is a very hot commodity from a funder's perspective, lots of opportunity for growth. Why the innovation was a question that was put to me by the organizers of the conference, of the symposium. From the perspective of the law firms, why bother going to a litigation funder? And these are some reasons, but there are actually many more. I think in the class action context in particular, the need arose because traditional sources of financing, both debt and equity, have diminished post-2008. In the fee-shifting jurisdictions like Ontario, the unpredictability of adverse cost awards against representative plaintiffs, which really means against the law firm representing the representative plaintiffs, has really put a chill on the heretofore willingness of law firms to indemnify representative plaintiffs against adverse costs. There is the possibility that the failure to liberalize firm structures has also led to this kind of innovation. It's hard to tell. One lawyer that I asked this question of, a plaintiff side lawyer, said to me that using a third-party financier avoids awkward conversations with your client about the inherent conflicts of interest created by being your client's insurer or banker. The premise of that, though, is that lawyers are actually having that conversation, that they disclose when they decide to act on a contingency fee basis or to indemnify the representative plaintiff against adverse costs, that they are in a conflict of interest. I'm not so sure how many lawyers are having that conversation, but according to this one, you avoid that awkward conversation if you just use a third-party funder. Another lawyer told me that having third-party support actually has great optics. It heightens pressure on the defendant because it suggests that an objective observer believes your case is sound. It also sends the signal that the plaintiff has resources to withstand a war of attrition, and in that way truly levels the playing field. So what are the arguments in favor of litigation funding? Well, in terms of access to justice, an empirical study out of Australia by Vince Morabito does suggest that there has been an increase in the ability to access legal services, to go to court. But, the flip side of that, when very conservative corporate interests hear that, of course, they say, well, then what you're talking about really is that litigation funders enable a spike in frivolous lawsuits, that we don't want an increase in litigation. So that's sort of the flip side of the access to justice justification. But there is, as far as I can see, no evidence that there has been a surge in frivolous litigation as a result of support by litigation funders. Litigants, again, in theory, and I leave this to the economic experts on the panel, in theory, litigants can hold out for better settlements if they have financial support of a third party. So this would be an increase in substantive justice. So not just the number of people who are able to litigate, but also the outcomes that are achieved. And in the Giuliani case, I mean, I've given you the horror story of that, but the plaintiff's lawyer submitted to the judge, and the judge accepted that plaintiff would not have been able to litigate the personal injury action without the financial support of the lawsuit lender. That she could not have paid for experts without that financial support. So there is an ugly underbelly, but the fact remains that there are people who need financial support to access the system as it's currently structured. So this doesn't help us in terms of remedies or reforms that need to take place to make the system more accessible. But if we keep the system as it is, with its lengthy delays, and with the fact that lawyers are needed in certain types of cases, then litigation funding does increase financial support to enable people to access those traditional forms of legal service. Contingency fee lawyers, especially on the class action side, say that this is going to open up the market, that you won't have just a few well-resourced class action firms able to litigate these types of cases. So it will lead to greater competition among lawyers. The presence of the funder, who presumably is much more entrepreneurial minded and financially rational, will ensure that lawyers stick to budgets and so on, so it will generate greater efficiency and less cost. And this is a point that Professor Iacobucci talked about. It's not on my slide, but that when you can diversify, when you can unencumber the lawyer from the business and the financial pressures of conducting the case, the lawyer can actually concentrate on litigating and leave the business side to the funder. In terms of consumer protection, I put that there because there's also sort of at a more normative level this belief that if you increase the ability for litigants to vindicate their rights, particularly in small claims, then you're performing a deterrence function, that there will be less impunity on the part of corporate wrongdoers and therefore greater consumer protection. So this is at a sort of meta level. And then this is an argument that Professor Trebilco made at a conference that we held at the University of Windsor in July on litigation funding. There is a theory that funders can actually act as more effective monitors of lawyers. So there are agency costs inherent in certain kinds of litigation, particularly class actions, where the question that I and others have asked is, who's guarding the guardians? Who is an effective monitor of what class counsel are doing? And one argument in favor of litigation funding is that you've actually got a really sophisticated party, i.e. the litigation funder, who can monitor the work of the lawyer. Before I go, well, I'll go to the next slide, because the caveat is that this is a particular kind of access to justice improvement. It does maintain the status quo in terms of the cost of legal services. Query whether it actually will lead to a rise in the cost of legal services. It It maintains the status quo in terms of the length and expense of litigation. It doesn't reduce the cost of litigation necessarily, but it does increase funding options to help pay for it. And so the arguments opposed are actually the flip side of the ones I've already talked about, both on access to justice and consumer protection fronts. There is a fear that funders, like the one in the Giuliani case, like the one out in BC with the residential school survivors, are simply going to engage in financial exploitation. And even without the evidence, such as it is, 2 reported cases, I don't think we need to wait for a deluge of complaints about nefarious practices before the Law Society takes note. There's also, on the substantive access to justice question, a worry that what the presence of this third party does is simply reduce the level of compensation received by the plaintiff. You know, one of the lawyers I asked about the why question, why are lawyers attracted to litigation funding? The answer is, what's the downside? It doesn't reduce my share of the pie, because the funder gets paid after the lawyer gets paid. So if their contract says they're entitled to 7% of the proceeds, it's net of lawyer's contingency fee. So it doesn't reduce the compensation level for the lawyer. It reduces the compensation ultimately received by the plaintiff. So from a substantive access to justice point of view, I think we need to bear that there is a cost to this innovation. And then on the consumer protection front, not surprisingly, because of the financial exploitation possibility, it is an unregulated market. There are no caps on fees or on rates of return. There is a worry that our courts have addressed in the class action context, particularly Justices Strathy and Perel, that we don't want to see the third party stripping the client of power and influence. There's a worry of intermeddling and control. And this is a concern that has loomed large in the UK and in Australia. In Australia, the courts have blessed intermeddling, if we can use that term. So in Australia, it is perfectly acceptable, ethically and legally, for the third party to have control of the litigation, to have a say on settlement, on how the case proceeds, and so on. I think, not surprisingly, Ontario judges have said the opposite. And so they've insisted that in the contracts they've approved in the class action context, so again, in the class action context, the agreement is getting judicial oversight and approval because of the nature of the class action regime. We don't have that oversight function in the personal injury sector. So the contracts in that sector are very much under the radar. So there are worries about the client being stripped of power and the usual authority to instruct counsel, and incentives for self-dealing. I've probably run out of time a long time ago. The last 2 slides, which I think you'll have on your USB key, are some possibilities for regulatory response. At the Law Society level, let me say, this isn't the first time the Law Society has considered litigation funding. And I think Jim is in the room, Jim Barrow, thank you. During my investigative stage for the paper last year, it turns out that the Law Society in 2006 had a subcommittee which examined litigation funding and ultimately recommended that the industry be monitored. In a piece, I think by Sandra Rubin in 2011, the Law Society representative is reported to have said that since there have been no complaints about litigation funding, the Law Society is not studying the topic. I guess that's changed, or is about to in the next 5 minutes. So some of the areas that the Law Society might want to consider are, again, the questions of control. A lot of these contracts give the funder, understandably, a right of exit, but does that right of exit then de facto mean that the plaintiff loses its authority to hire and fire lawyers at will? Questions of conflict of interest, again, there's that horrible case out in BC of the 77 clients, I said 170, it was 77 clients being referred to one funder by a law firm. Justice Brown earlier this year actually banned that law firm from representing any IRS claimants because of its conduct. So the Law Society also has a bylaw which requires its members to disclose affiliations with non-members. I don't know how many of our members have disclosed to the Law Society that they have affiliations with third-party funders. So disclosure of the arrangement to the Law Society and to the court and to the client, I think, are matters which may need to be reviewed. Independent legal advice, something as basic as our clients being told to get legal independent advice before they sign on with a funder. Questions of confidentiality and privilege, I know have been a topic of study by both Brad and Anthony in the States. Does the entry of a new party to this binary relationship wreak havoc on our particular rules around confidentiality and privilege? And then finally, as I mentioned, the client's right to terminate. The relationship, I think, is under some pressure as a result of the third party. There are other regulatory responses for others to consider, the legislature, as well as the possibility of self-regulation, which was successful in part in the UK, supported by Lord Justice Jackson, but perhaps Professor Flood can fill me in on what's happened since, because I think there was legislation or a bill introduced in the House of Lords amending the Legal Aid Act to regulate the sector because many believed that self-regulation was the wrong way to go. For more information, I have some citations there for you, including the paper that I published with an Australian and American. And then Professor Trebilco's paper coming out of the July conference will be forthcoming in the new year. Thank you very much.
So I'm going to throw a couple of very short questions to our panelists because we are behind, and I do want to give an opportunity for a few questions, at least from the floor. We were going to turn back to Professors Iacobucci and Trebilco just to comment on what they've heard from James and Yasminka, and I think it would be helpful to hear from them. We've heard now essentially the market's happening, the liberalization is happening, but James suggests a lot of it's happening outside of the regulated market and the lawyer market, and I think Yasminka has added to that concern. So tell us sort of quickly some thoughts arising from what you've just heard from our other speakers.
I mean, I think it's interesting how, although the sort of foci of the two subsequent presentations were different, the lessons are actually very similar. So there's going to be certain economic forces that are just going to exist. There's going to be certain ways of doing things that are going to be better than other ways of doing things. And where that's true, there's going to be economic pressure, you know, in competitive markets to adopt those better ways of doing things. What we're hearing is that, you know, on the tech side, this sort of explosion in these startups, and certainly James identified it explicitly, is that they're moving out of the law firm and into these startups because there are restrictions on doing things within the law firm. Yasminka is identifying that we're getting these third-party lenders because there's, to me, one way of interpreting that is because there's restrictions on the way that the firms themselves can be financed. You don't necessarily have to do it on an ad hoc way, but if there's restrictions on financing within the firm, then you're going to see these sort of third-party arrangements. So I think they're picking up kind of the Coasian, you know, there's, you know, an implication of Coase is that sometimes activities are better organized within the firm. If there are restrictions on what you can organize within the firm, market pressures are going to get firms to do as much as they can within house and then try to strike third-party arrangements to substitute for what they otherwise do. So it was quite illuminating and interesting to me to hear.
Professor Trebilco, I wondered if it pulled you back to your thoughts on the importance of access to justice and how we have to balance that with efficiency.
I think one reaction I had to James's presentation is that a lot of these innovations are driven by IT and the very substantial investments required to fully exploit the potential of IT. So, you know, small law firms, you know, solo practitioners or 3 or 4 person law firms, with either unlimited liability or partnership form, even limited liability partnerships, just simply can't capitalize these investments, right? They're out of the game. But I noticed that some of James' examples really were a kind of contracting out, right? The online provider is really a kind of referral agency that kind of links clients with lawyers in independent practice. So this is really contracting out in a way. The online service is sort of orchestrating a contractual network of referrals. So this is not a single firm, right? This is a whole complicated set of contractual arrangements orchestrated by the online provider. So I think of that rather differently from these kind of services being provided in-house, right? Which seems to be the model adopted by some of these other online services.
James, I wanted to just come back to you because you didn't say it explicitly, but some of what you were hinting at, I think, suggested that you see the case for lawyers to be more directly involved in these innovations. Just follow up.
Yeah, I think there's fantastic opportunity in that realm. I just think it's difficult the way that things are structured today to make that actually happen. I think, again, a lot of lawyers themselves are involved in these innovations, but they're not practicing anymore. So they're stepping away from practice to be able to innovate and provide these services. I think it'd be a more powerful innovation if it was able to be backed by integrated legal advice rather than segmented, where you've got the technology innovations on one hand and the legal advice component on the other hand. It's just that, generally speaking, not allowed to do that. I think there are very few examples where you can have lawyers working for a company and providing legal advice. So unless you have the lobbying power of the insurance companies in the US, you're not allowed to have an in-house legal department provide advice to your customers. So I think fantastic potential there if there was some regulatory changes that allowed it to happen. But I don't see much of it happening in the current structure.
And Yasmika, let's pull you back to this access to justice point, because that's, as you said, where
I
your
didn't flog that horse.
well, it's where your work begins. So as you told us, and I mean, I think some have said that too much of an emphasis on client protection, perhaps driven by our regulatory approach, does compromise access to justice, so that in fact innovation could benefit access to justice as a different form of our concern about the public interest. Just want to pick up on that theme for us?
Well, I think, what I would caution is when we talk about access to justice that we be precise about what it is we mean. So if we adopt, and I wrote it down, so in Tom Conway's introduction, he actually said access to justice does not equal access only to licensed lawyers. And I would say, so access to justice doesn't necessarily mean increasing access to traditional legal services and to the court system. And so, litigation funding, to take the example, does increase access to justice. If you define it as access to traditional legal services and access to very formal court processes. And I'm not making a normative judgment about that, good or bad. It is what it is. And if we are interested, if we are concerned, for example, about the rate of unrepresented litigants, then litigation funding potentially has a lot to offer. If we're concerned about repeat players, defendants who have a scorched earth policy when they litigate against vulnerable plaintiffs, and we want plaintiffs to have a more level playing field, then litigation funding has some potential benefits. But nothing is a total solution, but this is perhaps part of the puzzle. My caution is that I am concerned for the Giulianis of the world and the Indian residential school survivors of the world. So if, it is the Wild West out there. And so access to justice also means protecting users of the justice system to make sure they're not being taken advantage of.
Question from the floor? Can you jump up to the mic just so we can hear you?
My name is Julia Bass. I'm policy counsel here at the Law Society. Something that the Law Society has looked at with some interest is some of the European experience with legal expenses insurance. And I wondered if Professor Trabilko and perhaps other members of the panel would just mention whether they see any role for where legal expenses insurance meets ABS. That seems to me to be an interesting area.
Thank you, Julia. I think the question is very well taken, and I don't know whether you're aware or not, but Sujit Chaudhry and I and James Wilson, in a paper in that a volume that I mentioned earlier, Middle Income Access to Justice, have a paper precisely on legal expense insurance plans. We engage in some utopian sort of blue skying in that paper, and think of LAO, Legal Aid Ontario, running some kind of province-wide legal expense insurance plan where they would try and drive legal costs down by conditioning the terms on which insurance would be available to reimburse legal bills on innovations being adopted by the legal service providers. That is, you wouldn't better gold plate the service if you could get by with paralegals and others, right? So this would be like a single payer system by way of analogy to the healthcare system. So I think there is some potential here, but legal expense insurance plans in Canada have not really taken off unless something's happened in the last year or so that I'm not aware of. I think in Quebec they've had somewhat more success, but my impression is compared to Europe, which is what you're thinking of as the benchmark, they're a relatively small part of the access to justice equation in Canada to date, which is disappointing to me.
I'm trying to take one more question before we break for lunch. Sure.
Sorry, my question is more of perhaps an economics question as to how we would envision perhaps regulating a multidisciplinary practice, particularly when we have externalities that are faced with a business firm that perhaps can internalize that because of some other factors, like the Law Society, maybe the chartered accountant that have perhaps contrary regulations, but they're trying to find some common ground. So the question I would ask is, how could the free market incorporate MDPs?
I guess the starting point, actually, I'm going to give an answer similar, again, to what Professor Terry said in the first panel. I think that the question I would start with is, when you speak of these of externalities, so an agreement between two people has some negative effect on the third party, I think you want to be very careful about what those are exactly, right? That is, it's easy to sort of say that, and certainly some values to the legal profession that we take very seriously, but I think we should think hard about whether these sorts of combinations actually threaten those values and whether there genuinely are these externalities. And of course, if we conclude that some values are in jeopardy, then we will have to have restrictions that may impede the kind of formation of some of these ABS. But I think, and I think the spirit of the discussion today is very helpful, which is let's an economist, let me put it this way, I think an economist approaching this would say, and I think I said this in my first meeting with the working group, from a regulatory perspective, let her rip. Let's just, let's open it up and see what arises. From that starting point, we may want to construct restrictions because we're concerned about third-party effects and other sorts of things. But the starting point from an economic perspective is let's let the market work. And it's only where we can identify problems that we would want to cut back. So I think I would just say, so it's not a specific answer to your question, but again, it's a mindset in thinking about how to approach that. I would start from an economic perspective that there are potential gains here only if we can show that there are some, clear probabilities of losses if we do this, should we regulate.
Can I just add to that? Anytime one talks about innovation, it could be organizational innovation or technological innovation, just the very concept of innovation means that ex ante one doesn't know whether it's going to work out well or not. I mean, James Peters made that point, that these are very risky investments. So, I assume BlackBerry thought that when Apple came up with the iPhone that this was not going to be a terribly attractive innovation for customers, but this turned out to be a disastrous misjudgment. This is by way of amplifying Ed's point. We could anticipate all kinds of failures and miscues and potential problems and close off these, quote, innovations even before we try them, right? We can construct a horror show of potential mishaps such that innovation never gets off the ground. The alternative is to be somewhat more liberal up front, but be alert and proactive in monitoring the evolution of these innovations and identify real problems, not hypothetical problems, real problems as they materialize, and then regulate accordingly. But a massive array of preemptive regulations is inconsistent with the very concept of innovation. So I think there's an issue of whether you're going to put a lot of emphasis on ex ante preemptive regulation or ex post regulation of actually revealed problems.
All right, I don't want to keep you from your lunch. I want to thank our panelists. I think they've helped us to explore some of the possible benefits of liberalization, and certainly they've taken us down the path towards the inevitability, perhaps, of liberalization. We're going to try to reconvene again at 1:30. I hope you'll join us, because at that point we're really going to start making you do the work and engage you more in the conversation. Enjoy your lunch, and we'll see you then.